Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives in New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, happy Sunday. Happy Sunday, my friends. Today is the full moon and the end of Mercury retrograde. If you know, you know. If you know, you know. It says Mercury retrograde ends today as the full moon peaks. So we got that going for us. This is also last full moon of the year. And shout out to Travis Hunter for winning the Heisman Trophy last night. So proud, proud Colorado alum here. And that was pretty cool. I was talking about that yesterday. Yesterday I did a stream on these Alexander brothers. And a lot of people didn't know what they were in for when they tuned in for this. Because if you've been busy all week doing other stuff, you might not have heard the horrific tale of the three Alexander brothers. Very, very rich men from New York and Florida, tons of money. They've sold billions of dollars in real estate, and they've been indicted in federal court in New York for conspiracy to commit trafficking of women, which it turns out that they have been sliding into these women's DMs and finding them on dating apps and flying them to their houses in the Hamptons and Tulum and Miami, and drugging them and then forcibly committing offenses on them for at least 20 years. It's horrific. This happened. They're trying to get them back to New York on federal charges. So they're going to have a hearing tomorrow. If it's going to be streamed anywhere, I'm going to stream it live because these guys need to get put away and never see the light of day. The problem is, and this is why they had to get some conspiracy charges in there, is that statute of limitations on some of these offenses are expired. And there's about 40 women involved in this so far, and it's only going to get worse, I fear. But I did see something inspiring that I wanted to share with you before we move on to our topic of the evening, which is going to be the Schiffer case, the Richard Schiffer case, because so much other stuff was popping off. We never really got a chance to watch that hearing with Tim Bradel shining. Good to see Tim Bradel in the spotlight. And you may recall, I did a show on this back. I linked it below. On October 1st, I did a show on this, and this was about Richard Schiffer, man from Canton who was charged with felony witness intimidation and littering charges for placing some little tiny rubber ducks around town that had stickers on it that said Colin did it and IYKYK. Canton PD did a thorough investigation over the course of 6 months. They drafted a 36 or 38-page police report on this Schiffer matter, the Rubber Ducky Gate, as we came to call it. And when I went back to watch that stream again from October 1st, I remembered how funny it was and how on fire the chat was that night. We had every duck pun that we could think of. You guys were hilarious. That was the day that we decided we were just going to use the word duckin'. instead of the F word, which we never use on this channel anyway. And I made a special rubber ducky emoji, and you guys have it if you're members. And two-man Tim Taylor was the detective in that case, and he did such a thorough investigation of Richard Schiffer and these rubber ducks that were, as they say, littered about town and rose to the level they thought of felony witness intimidation. Their investigation was so thorough. First of all, it was well more executed and far more thorough than the investigation of the murder of Officer John O'Keefe. I mean, that goes without saying, but they did trash pulls. They went to Richard Schiffer's house and pulled his trash and sorted through his trash and found envelopes where these stickers were purchased on the bottom of these rubber ducks. They called the sticker company. I'm going to shout them out, makestickers.com. They called that makestickers.com, and they were micro ducks. I think they were micro ducks. And they wanted to get the information for Richard Schiffer's purchases of these stickers. And props to Adam, the owner of makestickers.com, because now I'm going to shout him out whenever I can, who said, yeah, get a warrant. So they did. They got a warrant. And then found out that Richard Schiffer might have ordered some more stickers at different times. So they called Adam back. And Adam said, get another warrant. And they did. They got all the warrants. They got all the purchase records for these stickers. And then they got the purchase for the stamp, because not only did allegedly, well, he admitted to it, put these little teeny weeny rubber duckies that are like this big around town with the little stickers on the bottom, thinking it would be a fun thing for kids to find. And also because, it's protected speech under the First Amendment. Some of the stickers said Colin did it. Some of them said IYKYK, which if you don't know means if you know, you know. But also some like monopoly money or counterfeit fake prop money, $100 bills stamped with Officer John O'Keefe's, I think, badge number and date of death. And, he was charged with littering those as well. And we went over that thoroughly. Trash pulls. What else did they do? Trash pulls. They did some, they pulled footage from like traffic cams to show that Richard Schiffer was in the area when some of these ducks were found. And also they went to where his business is with the forensics guy from MSP or Canton PD and downloaded the infotainment system from Richard Schiffer's Toyota truck to prove that he was in the location of where some of these rubber ducks and fake $100 bills were found. They did the most thorough investigation on this that really, I don't know if anyone in Canton has ever seen a more thorough investigation. I will bet you that the police report that comes out on the trashing of that poor girl's home that was being built by some of the Canton high school students, where they demolished the interior of that house that was being built to the tune of, I don't know, $100,000 or more. And then may have kicked around a dead rabbit and a dead squirrel and or killed both. I bet the investigation of that is going to be far less thorough than Richard Schiffer's investigation. But that's just my opinion. And I guess time will tell. Time will tell. So what we didn't get to look at or stream was the hearing that took place on December 9th. What did I say today was? Today's December 15th. So it was like already like a year ago. But shout out to Tim and Andrea at Canton Community TV who sent me the link to the actual video footage of this hearing. So we're going to get to actually watch good video of it. We're going to see Bradel shine. And then we're going to look at the written decision by Judge Brian K. Walsh. Brian K. Walsh needs a promotion. He needs a promotion. They need to get him out of Stoughton District Court, and they need to rise him up, give him a promotion to Superior, give him a promotion to Norfolk Superior, because this man gets it. He gets it. We're going to watch the hearing. We're going to read the decision. And then when I was talking about the Alexander Bros yesterday and all of those heinous crimes and going over their indictment, some people who were watching said, can you go over the SJC decision that came out on Friday on a different case? So it's not on the Karen Reed case. It's on a different case. But it's going to be very telling, because not only is it the same panel of judges, but they are expanding your First Amendment rights in Massachusetts, my friends. They're expanding your First Amendment rights. Can you believe it? Instead of trying to constrict your rights, they're actually expanding your rights. And you know what else they did in that decision? You know what else they did? revised some jury instructions. Oh, yes, they did. Oh, yes, they did. And they're not afraid to do it. So, in my opinion, good thing for Karen Reed. And we're going to look at that decision because a lot of people wanted to talk about it. They wanted to hear me explain it. So I'm here for it. We'll do it. But the first thing that I wanted to do for you, because I know so many of your parents and grandparents, and we like to look at inspirational things. Travis Hunter's mother gave a little speech last night after he won the Heisman. And I loved this speech because I thought, as mothers, especially some of us are single moms, right? And as mothers, we do the best we can, right? Every day we get through it is a good day, right? It's going to be a good day. Here's Travis Hunter's mom giving her little speech about how she raised Travis. And I thought this was really amazing. Let's take a listen because I find it to be inspirational. And I'm thinking about inviting her to be a guest on the show. And I think that should be a great guest. So just listen. Her son just won the Heisman for, yes, Deion Sanders, University of Colorado Buffaloes, Heisman Trophy winner, Travis Hunter 2024. Here's his mom, who's being interviewed, Scobus, after he just won his award last night. Oh, well, it'd be good if you'd let me play the sound. Thank you. Hello? There's a little sound thingy. Oh, there it is.
Years start to fall. What did you think when they called his name?
All right, girl, I'm going to have to. Instagram is like the worst platform. You can't like rewind anything. It's like
Travis's mom, and as you hear his name called,
wasn't that awesome? Doug Flutie was there and a lot of other like Heisman winners. It was so cool. You are the prize. You are the prize. And she said at one point, like, this is some people said this was like the biggest mistake I ever made, and I'm not sure what she was referring to, but she has 3 boys, and I think one of them is still kind of little. And like she's like, and I just told him, you're the prize. You're the prize. It's not about the Heisman. It's about you. Wherever you go, you're the prize. Isn't that amazing? I just love that so much. Anyway, she's an inspirational speaker. I found her on Instagram and I thought, wouldn't it be so cool to have her on the show and like ask her, teach us all how to raise Heisman Trophy winners. Teach us all, because whatever you're doing right, right? I love that. Women helping other women, strength in numbers and strong women. And yeah, how long till the Karen Reed? No clue about sports. I don't know. How long? I'm not talking about Karen Reed tonight. We're talking about Richard Schiffer. We're talking about another SJC decision. So if you want to hear about Karen Reed, that's not what we're here for tonight. I don't think that's what the title said, did it? So there's that. Okay. Wasn't that sweet? Her mistake was having a baby when she was so young. I think that's it. Yeah, she's got to be super young. I mean, I don't know, he's still in college. And I don't know that he's been in college for more than 4 years. So maybe he's 21. She looks really, really young, right? He won the prize when he got that mom, says Cuzco. That is right. Look at that. 3 of my adult kids work for the city of Boulder, and one of them is a firefighter. That's amazing. I love Boulder. I have special ties to Boulder, and I went to one of the games this year. It was Peggy's 100th birthday, where they celebrated Peggy's 100th birthday, if you know, you know. And it was awesome, and I talked about it, and there's that. All right, sorry about your Patriots, and they didn't win tonight, but in any event, we're going to take a look. First thing we're going to do is we're going to look at the actual hearing. Thank you again to Canton Community TV for sending this to me. And here we go. Judge Walsh needs a promotion, I say. Karen Reed fallout. Yeah, Karen Reed fallout. So it's like the fallout from the Karen Reed case. The reason that Richard Schiffer, his duck case, has to do with the Karen Reed case is because Richard Schiffer, is accused of intimidating Chris Albert and Colin Albert with his stickers and his ducks. So this has to do, it's a parallel to the Karen Reed case. Okay. Karen Reed, doesn't say Karen Reed fallout. Karen Reed fallout continues. Rubber Ducky case. People know. If you know, you know. If you don't, you don't.
Hello, Your Honor. This is Grado on behalf of Mr. Schiffer. He's at the bar, not in custody for the record. Good morning.
All right, Mr. Schiffer, good morning to you.
Good morning.
And Colin. Good morning, Adam. You have the motion?
I do, Your Honor.
You ready to argue?
Yes, Your Honor.
All right. Mr. Brady, I'll hear you whenever you're ready, sir.
Thank you very much, Your Honor. Your Honor, Mr.
This is great. So it's awesome that Canton Community TV was the pool camera that day, because we never get to see these things unless they're on Zoom, and sometimes they're audio only and we get nothing. So it's Tim Bradle's day for the spotlight today, when this was on the December 9th, right? Okay.
Schiffer comes before the court charged with the felony of witness intimidation, the misdemeanor of criminal harassment, and several counts of littering. The defense argues arguendo and doesn't assume any or admit any facts alleged, Judge. This is all assuming the facts in the light most favorable to the Commonwealth. So we don't, the way I argue it will not be an admission of any conduct on the part of Mr. Schiffer, if I may. Judge, this case starts out with a 37-page criminal complaint that lays out laborious efforts on the part of the Canton Police Department to send subpoenas and find and execute search warrants and constantly visit Mr. Schiffer and look for statements and evidence. The problem for the Commonwealth, however, is that this 37 pages is an investigation in search of a crime that never happens. There's no crime here, Your Honor. In terms of witness intimidation, Your Honor, there's no predicate act that can be looked at by the court in any possible way as a predicate act that would trigger the statute. There's no threat. There's never been any contact whatsoever between Mr. Schiffer and these complainants. There's no allegation. There hasn't been any actual face-to-face contact with these people. So if you have to go through the motions of it, you have the only possible predicate act can be a threat towards these complainants. There's no threat. A threat is not, it's not communicated to any specific person. There's no realistic, way that distributing a leaflet or a rubber duck can be perceived as a threat directed at a particular person. So the whole thing fails on the predicate act, Your Honor. It's absolutely absurd to assume that there's some sort of threat that arises out of this. The second factor here, Judge, in terms of Mr. Schiffer's expression, all of these acts are completely protected by the First Amendment. I'm not going to go through all the case law. I put it in my motion, case after case after case, protects much more egregious conduct, protects even facially apparent threats are protected in most contexts. So there's really no way that the government can proceed in terms of this felony charge. Same thing on the misdemeanor criminal harassment, Your Honor. Same thing here. As the courts, I'm sure well aware, I know you deal with this every day, O'Brien v. Borowski limits the grossly overbroad reach of the criminal harassment statute to only true threats and fighting words. And here, there's no true threats, certainly no true threats for the reasons I just got into, and there's certainly no fighting words. That's not even on the table. So O'Brien v. Borowski also limits the fear that's in the criminal harassment statute to fear of criminal consequences, bodily injury, damage to property. Not fear that I'm going to get sued, not fear that I'm going to lose accounts, not fear that I'm going to be upset by people's speech. So all these things, Judge, are completely insulated from criminal scrutiny by the First Amendment, which of course, again and again, I see in these cases is completely ignored by not only the Canton Police, but the state police, Your Honor. They need a seminar on federal constitutional law.
They need a seminar on federal constitutional law. Is that amazing or what? They need a seminar on federal constitutional law, Your Honor. This is insane. My client has the right to free speech. He didn't even speak to any of these people directly, ever. And as you can see, the defendant, Richard Schiffer, in the striped shirt, looks like he just wants to throw up. He's like, what am I doing here? Maggie wants to know, what's the significance of the duck? Well, in closing arguments at the Karen Reed trial, Alan Jackson said, as part of his closing, if it walks like a duck and it talks like a duck, it's a duck. And that is where that came from, which is also a famous quote, which you're going to see this judge is going to also use in his written decision. So it's interesting. Right. Exactly, LA. Exactly.
And, ignoring it is just not acceptable for a public agency to just go ahead and charge people and let the chips fall, cause them emotional distress, cause them money, cause them time out of their schedule, risk harming their reputation. It's outrageous. And we have a lot of faith. My client and I were talking about this court. We have a lot of faith and trust in this court, Your Honor, that you're going to see that for what it is and do the right thing in terms of allow the man to have his First Amendment rights. The last thing I want to say, Judge, is that Mr. Schiffer is charged with littering. There's a case right on point, U.S. versus Schneider out of New Jersey, Your Honor. You're not allowed to selectively use littering laws to enforce a viewpoint. And that's exactly what's going on here. And there's absolutely no other enforcement of this law that's ever come into this court that I know of. If the court feels there should be some factual finding as to selective prosecution on littering, then I would ask that the court schedule a hearing and we can get some discovery from the Canton Police Department and see what exactly viewpoints do they use to employ the littering statute. And I guarantee you there's only going to be one viewpoint where they employ the littering statute, and it's anyone that's in favor of the Karen Reed camp versus the Canton Police, Mass State Police camp in the murder prosecution of Karen Reed. So it's selective prosecution.
And that, my friends, is how it's related to the Karen Reed case. In case you were confused by the title, that is how it's related. Because this is what's going on. They're weaponizing the law against anybody who thinks that the police did a shoddy investigation and or zero investigation, who thought that perhaps there was some personal ties between some of the investigators in the case and some of the other percipient witnesses in the case, and who may in fact think that John O'Keefe was not hit by a car. And the laws are being selectively used to prosecute certain people in Canton and the surrounding towns who are vocal about it. And this is one example.
It's viewpoint discrimination. I gave you the case. This whole case, Judge, we respectfully ask, just wipe it clean. Throw it out of court, as they say. Thank you, Your Honor.
Thank you very much, Ms. Benton.
Thank you, Your Honor. Judge, Commonwealth is asking that you deny the defendant's motion to dismiss as
Okay. Remember, she's on, first of all, she's on regular speed. And she speaks very quickly. And she's on fire here. She's got her argument. She's going with it. She's got her marching orders. Here she goes. This is the ADA.
probable cause does exist within the four corners of the complaint application to support the accusations as charged. In terms of the criminal harassment statute, Judge, the instructions read, whoever willfully or maliciously engaging in a knowing pattern of conduct that seriously alarms or would cause a reasonable person to suffer substantial emotional distress. The report indicates, Judge, that was part of this complaint application, that the defendant has done just that. The application alleges that the defendant willfully, on at least 7 separate occasions, directly placed items, rubber ducks, fake $100 bills, within various locations throughout the town of Canton. These locations were specifically targeted by the defendant. 6 out of 7 of the times that these items were placed, that are outlined in the complaint, were at a specific location.
And you remember when we went over this 36-page report in the show that is linked in the show notes below back on October 1st, it was like, they just said that in the report. It was just like, and the witnesses have been humiliated and embarrassed and emotionally harmed. But it was just a blanket statement. There was no statement from Chris Albert or Colin Albert saying how this had affected them in any way. There was no interviews with them. It was just blanket statements made by Tim Taylor, Detective Tim the Toolman Taylor, which, by the way, is not a diss. It's a reference to those of us who used to watch that show, Home Improvement. That was the character's name, right? Tim the Toolman Taylor. Tim the Toolman Taylor. Blanket statements. And you'll see in the written decision.
6 of those times were at D&E Pizza in Canton. D&E Pizza is a family business owned by Chris Albert, a business where his son Colin Albert frequently is present at. And the messages on these items referencing Colin did it are directly related to the owner's son, accusing him of the murder of a Boston police officer, John O'Keefe. Both Chris Albert and his son Colin are witnesses in that trial, were witnesses in the previous trial, are expected to be witnesses in the later trial. And again, Your Honor, this location was targeted nearly every time.
I didn't read the police report in the way you just characterized it in terms of at that specific location. I read it that it was Canton Center in the vicinity of that business and a number of other businesses. Am I incorrect?
He's like, yeah, that's not exactly how I read it. He didn't like go inside D&E Pizza and leave him there, right? Or leave him outside. It was kind of like in the area of D&E Pizza. He's picking it up. He's not buying what she's selling here. Listen.
Correct there?
You're not incorrect, Judge. They were placed in various locations. However, 6 out of those 7 times they were in the direct vicinity. I believe the report read within 200 yards of
200 yards. 2 football fields away, Your Honor. Wasn't the buffer zone around the courthouse 200 yards? That's interesting too, isn't it? 200 yards comes up a lot in Dedham, in Canton. 200 yards, within 200 yards of D&E Pizza. That's a stretch, don't you think? I don't know. I think the judge is going to think so. Let me, whoops. Get out of his way so you can see him as well. 200 yards.
that.
200 yards?
I believe so, of
That's
that
2 football
location.
fields away from,
Yes, Your Honor.
right, and I know, I can't see 2 football fields right now. My own eyes, but, okay, go ahead,
Sometimes I cannot.
keep going.
Okay. The Commonwealth would contend that this willful, targeted, and specific behavior would not only cause Chris and Colin Abbott, but any reasonable person to suffer emotional distress. In terms of the intimidation,
Any reasonable person would suffer emotional distress from seeing a little rubber ducky. That, by the way, I've heard that the little kids love to find little rubber duckies around town. Like it was exciting for them. Did she really just say that? Anybody would find it to have emotional distress? Hold on. I got to hear this again. I got to hear him also say 2 football fields. I can't even see 2 football fields away.
Fields away now, my own eyes, but, okay, go ahead,
sometimes I cannot.
keep going.
Okay. The Commonwealth would contend that this willful, targeted, and specific behavior would not only cause Chris and Colin Abbott, but any reasonable person to suffer emotional distress. In terms of the intimidation of a witness charge, Judge, a portion of that intimidation charge holds that any person who willfully or directly threatens, attempts, or causes emotional injury or to harass another person who is a witness or potential witness in order to harm them for their participation in court proceedings. As stated previously, Judge, these spots are specifically targeted by the defendant. If you look at the jury instructions in regards to the intimidation statute, it reads, you can examine the defendant's actions and words and all the surrounding circumstances to help you determine what their intent was at the time. Commonwealth that would allege that it's not necessarily about a threat made to the victims. It's about what the defendant's actions were at that time. It does not require that the victim be placed in fear or apprehension or harm. The fact finder, being judge or jury, can evaluate the circumstances of what the defendant intended at the time of what he was doing. These specific locations included the businesses and residences of the places of employment for witnesses during that trial. And separate and apart from the criminal harassment and witness intimidation, Judge, the littering charge, these items were thrown and littered not only at the businesses in the town of Canton, but at residences of witnesses that are taking part in that Commonwealth versus Karen Reed trial. The police report goes on to explain that specifically at one point, the defendant is alleged to have placed these rubber duckies on the property of John O'Keefe's residence, where his elderly parents reside along with his niece and nephew, who again were witnesses in that prior trial. The police report alleges the defendant admitted that he littered and spread this propaganda on several occasions.
Yeah, that he littered and spread this propaganda. Where are we living? Are we in the United States anymore? I don't think there's any evidence that he put that on One Meadows, by the way. Well, did they get that body cam footage or that, flock cam? Coincidentally, their traffic cams are called flock cams. She's reading a script and it's really obvious. She's like, I don't know how I'm going to get through this as quickly as I can without being embarrassed. We are living in the upside down. We are, Meredith.
At one point during a live stream, he stated while holding up one of those ducks that said Colin did it, that this is a trigger word.
He said that this was a trigger word during someone's live stream. So now we're like YouTube is coming into your prosecutions. Okay. Trigger word.
It's it's not the items. It doesn't matter that it's a rubber duck or a
It doesn't.
fake $100 bill. It's just the pattern of harassment,
That's it.
witness intimidation. It's systematic. It's not an issue of freedom of speech, Your Honor, when you have a campaign of criminal harassment that specifically targets a select group of people for purposes of harassment in a murder.
Well, that's funny that you're saying that as the ADA, because you're specifically targeting certain people with prosecution of these laws, right? You're specifically prosecuting a certain class of people who don't think John O'Keefe was hit by a car. And you're bringing them to court and charging them with felony witness intimidation charges. And yet you're trying to flip the narrative around a little bit. Ain't no luck. I learned to duck. Thanks, Kenny Peterson, for the Grateful Dead reference. Wave that flag. Wave it wide and high. Listen one more time.
Your Honor, when you have a campaign of criminal harassment that specifically targets a select group of people for purposes of harassment in a murder case. It's no threat. It's just simply
In
harassment.
a murder case, but if they have nothing to do with the murder, then how are they being harassed? Right? Make it make sense.
The Commonwealth is asking that you deny this motion to dismiss. It's evident, Your Honor, that within the four corners of this complaint, there's more than sufficient probable cause to support each and every one of these accusations, and I ask you to allow the case to proceed to a fact finder. Thank you.
The court officer was like trying to keep a straight face behind her. Did you notice that?
Bill, did you have anything in response?
Just a brief response relative to the location issue. I don't think the government's really can make an issue of the location of the protest. I mean, it doesn't make sense to protest something, 3 towns away from where the target of your protest is. And to leave things around in the general vicinity of downtown Canton, has to be protected under the First Amendment. That's where the parties are. That's where the town center is. And, that's perfectly acceptable. It's literally the cliche of protesting in the town square. That's where you're allowed to protest. So in terms of the location of it, shouldn't be used against anybody.
I also don't like how the ADA is standing with her back to her adversary or her brother counsel here. Tim Bradle, I don't like that. She's not even looking at him. These Massachusetts courtrooms are set up pretty weird.
Thank you.
All right, thank you. Thank you. All right, I do agree with the defendant that the application for the criminal complaint and related materials lacks sufficient probable cause
Wow.
to support both the criminal harassment and witness intimidation charges against the defendant. The defendant's conduct, in this court's opinion, did not rise to the level to support either of those charges, nor does his speech, which are afforded the protections of the First Amendment and Article 16 of the Massachusetts Declaration of Rights. Therefore, I'm allowing the defendant's motion to dismiss counts 1 through 4 only. At this time, the other counts will remain viable.
Wow. A judge who rules from the bench. Could you believe it? Not only did he rule from the bench, dismissing counts 1 through 4, which were the felony witness intimidation and criminal harassment charges, he rendered a written decision after this. Can you imagine? He didn't just say, I'm taking this under advisement and I'll get back to you when I do. See you when I'm looking at you, kind of thing.
Thank you, Your Honor.
Thank you, Your Honor.
That's it. So then now there's a couple of littering charges that
Judge, is the court
remain.
in January for dates? Or?
Sure.
Listen. Where are these people they're focusing on? I don't know.
January 17th, please, Your Honor.
Who's this guy that they're looking at?
All right, Mr. Schiffer, after hearing your motion to dismiss has been allowed as to counts 1 through 4, case will be continued to January 17, 2025 for compliance and election. We'll see you back here, sir, on that.
Mr. Bradle, you can get a copy of my decision.
Yes, thank you so much, Your Honor. I appreciate it.
Thank you, Your Honor.
Oh, and then he said after this, I think it was in like after like when he spoke to somebody outside on the courthouse steps, Tim Bradle said, yeah, we're going to ask for all of the people, we're going to ask for all of the cases and people that have been charged with witness intimidation in the past, like, I mean, with littering, that have actually been prosecuted for littering in like the last 5 years. And like, how many do you think there are going to be? Really? So now we're just going to go to trial on January 17th on some littering charges? Okay. How much money you think Canton PD spent on this investigation? The trash pulls, the subpoenas, the warrants, the telematics, infotainment data. I think they got a cell phone too, and they went through a cell. Like, it was insane. Joseph Kane, thank you. Gifted 1, 2, 3, 4 memberships. Thank you, Joseph Kane. Love you with all of my heart. Squirty Belly, David Reese, congratulations on Travis Hunter's Heisman. Thank you, thank you, thank you. I mean, I didn't do it. But, I have been saying all season, if Travis Hunter does not get the Heisman, then it's rigged. It's fixed. It's a frame job. So yeah, it was exciting to see. And also exciting that I wound up getting my Travis Hunter jersey in the end outside the stadium when I went to the game, because it was sold out everywhere. You can't get it anywhere. There was a guy outside on the corner, outside Folsom Field, selling them. He had one left. This one right here, one. $60. They're like 180 if you try and buy a real jersey like this, with a swoosh on Fanatics or something. Hi, Mozzie. Thanks for your super sticker and for tuning in from Australia. Samantha Jones, as always, coming in, looking hot. Good evening, all. Telling me I look beautiful. Oh, and paying me $5 to say that. Thank you so much. Uncivil Laws here. Singing the Rubber Ducky song. Thanks, Kurt, for the 5. Petty Paralegal says the Massachusetts State Police are the real witness intimidators. Yeah. So Yuri went to some houses of some people, right? He pulled right up to some women who had sent maybe some Facebook Messenger messages to some people in this case. And they had a big investigation on that as well. And I think those charges were dismissed. I don't know if there's a hearing on it, but did they decide not to prosecute on that as well? Petty Paralegal, thank you for the 25. That's so generous of you. Uncivil again is here. All of a sudden, I began to change. I was on the dance floor acting strange, flapping my arms. I began to cluck. Look at me. I'm the disco duck song. Oh, look, he's coming in. He knows, he understood the assignment. He's thinking in song lyrics too. Thanks, Kurt. Joseph Kane, mega drones. Anyone? Yeah, I don't know what's going on with those drones. I have a lot of questions. I don't even know where to start with that. I can't even like opine on that. Like, I'm just so confused about what's going on. Thank you, Joseph, for the deuce. Decline. Thanks for discussing with us on a Sunday evening. Oh, there's ain't no place I'd rather be than with balls of Hughes on a Sunday night. Motion to watch the classic Howard the Duck. Is that a hockey movie? I don't know. And so I don't even know that movie, but if you want to recommend it to people, you could do that. Absolutely, I'll allow it. VSPC, very serious podcast consumer, has been a member for 5 months. It says maybe Colin Smith won a track meet. Colin did it right. Right. Or he got into Harvard. Maybe he got into Harvard. Maybe there's a Colin out there who got into Harvard. I don't know. Squirty Belly. Colin did it. He got into Harvard. Just ducking around. Thanks for the super sticker. You guys are on fire as always. And thank you to Justin Green for coming in with the Cash App and thanking me. And also Cheryl says, I didn't realize YouTube gets a percentage. Let's use Venmo. Thank you, Melanie. Oh, thank you, Cyber Chicken Boston, so much. Yeah, they do. They take 30%. So yeah, Venmo is awesome. And if you want to send a Venmo and you want to remain anonymous, just say anon, please. And I'm happy to have you remain anonymous. Thank you very much, Cheryl. Appreciate you. All right, so let us take a look. Let us take a look at the written decision from our new friend, Judge Walsh. Judge Brian, of course his name is Brian. Of course his name is Brian. Brian K. Walsh. What are you going to do? It seems like everyone in your area, people, is named Brian. There's too many Brians in this case. It's not a lot I can do about it. All right. Here's his decision. Commonwealth versus Richard L. Schiffer Jr. Decision and order on defendant's motion to dismiss. This matter came before the court on December 9th, 2024 on defendant's motion to dismiss. This is not a fly on your TV. This is my cursor. I'm sorry, but I need to, it's the only way I can scroll. But I gotta go like this a little bit. Like this, and like this. An application for a criminal complaint must be supported by probable cause to believe that the person against whom the complaint is sought committed an offense. Where an arrest occurs without a warrant, a judicial officer must review the complaint application for probable cause to believe that the person arrested committed the offense charged before issuing the complaint. The complaint application must allege facts sufficient to establish probable cause as to each element of the offense charged. After the issuance of a complaint, the defendant or juvenile may challenge the probable cause finding by a motion to dismiss. The probable cause standard on a motion to dismiss a complaint is identical to that applied in the analysis of a motion to dismiss an indictment for lack of probable cause. Squirty belly. If you can make me laugh during the stream, you win. You win. These two dudes are decorated dudes. You wrong. You wrong. You wrong, dude. And then click. Thank you, David. By statute, criminal harassment is defined as follows: willfully and maliciously engaging in a knowing pattern of conduct or series of acts over a period of time directed at a specific person, which seriously alarms that person and would cause a reasonable person to suffer substantial emotional distress. That's general law, section 265, section 43AA. To support the complaint for criminal harassment, the Commonwealth must show that there is probable cause that 1, the defendant engaged in a knowing pattern of conduct or speech or series of acts on at least 3 separate occasions. 2, the defendant intended to target the victim with the harassing conduct on each occasion. 3, the conduct was of such a nature that it seriously alarmed the victim. 4, the conduct was of such a nature that it would cause a reasonable person to suffer substantial emotional distress. And 5, the defendant committed the conduct willfully and maliciously. Oh, we have to move to page 2, but because StreamYard doesn't allow it, I have to go stop, and then I have to do this, then I have to do this, and I have to go here, and I go here, and I get to page 2. Okay. Quoting Commonwealth v. Kulesa. Witness intimidation pursuant to General Law 268-13B requires proof of 4 elements. Okay, so are you following? Criminal harassment is 5 elements. Witness intimidation, 4 elements. 1, a possible criminal violation occurred that would trigger a criminal investigation or proceeding. 2, the victim would likely be a witness or potential witness in that investigation or proceeding. 3, the defendant engaged in intimidating behavior as defined in the statute toward the victim. And 4, the defendant did so with the intent to impede or interfere with the investigation or proceeding. The Canton Police report that accompanied the application for criminal complaint in this matter outlines a 6-month investigation that included search warrants, surveillance, witness interviews, and at least 1 confidential informant who turned over several rubber ducks to the police from a variety of locations throughout Canton, some found in Canton Center, quote, in the vicinity, end quote, of D&E Pizza, and presumably other businesses. It also contains the reporting officer's summary of the purported involvement of Chris and Colin Albert in the Commonwealth's prosecution of Karen Reed, his description of the views of, quote, conspiracy theorists, end quote, regarding what transpired on January 28th and 29th, 2022 at 34 Fairview Road, and his assertion that it is, quote, impossible, end quote, that a third-party culprit may be responsible for Officer O'Keefe's death. Yes. Oh, yes, he did. Oh, yes, he did. I remember us reading that and saying, why is he putting all of his personal opinions in this 36-page police report, Tim the Toolman Taylor? Although I will say Detective Taylor did a stellar investigation. These charges are BS, by the way, but he did a stellar investigation and he probably should get a promotion to something better than trash pulls and rubber duck investigations. If he was the one, if Tim the Toolman Taylor was on the detail for investigating the murder of Officer John O'Keefe, it might be a completely different case. I'm going to submit that to you. Yeah, look at Mama She. Mama She's like, I'm a rubber ducky informant. Yep. There were some people who wanted to remain confidential that turned in the ducks. It's true. It is true. You're wrong. You're wrong, Magdi. You wrong. Dixie, can I get Kevin from Southie as a guest? I don't know. I don't do the call-in shows because one of my besties, Duty Ron, warned me against that. He's like, don't ever do those call-in shows because you never know who's going to call in and what they're going to do on camera. I don't know if that ever happened to Duty Ron, but he's like, don't do it. And what Duty Ron says, I do. Okay, where were we here? However, nowhere within the 36-page police report, are there any statements of the Alberts that the actions attributed to the defendants seriously alarmed them or caused them substantial emotional distress, or any allegation by them of an economic injury to their business. There was nothing. There was nothing. Isn't that also the basics of proving your case, ADA? Don't you know? And I'm sure she does know that in order for her to prove her case, she needs the witnesses, the alleged witnesses, to say, I was alarmed by this. It caused me substantial emotional distress, and it caused me to lose business. People were calling in pizzas, sending them to people's houses, not paying for them or something. Nobody came to my pizza joint because they saw these ducks and they just assumed that my son was going to be there. And so they didn't want to come to my pizzeria. I don't know. And so I would think the ADA knew that going in. But there they were, causing Richard Schiffer emotional distress for having to hire and pay for an attorney to defend him in these bogus charges. The court finds the application for criminal complaint and related materials lack sufficient probable cause to support the criminal harassment and witness intimidation charges against the defendant. As discussed above, the complaint does not adequately contain factual support for each element of the charges sought. The defendant's conduct does not rise to the requisite level to support either of those charges, nor does his speech, or in this case, his written word on fake currency and the use of rubber toys, which are afforded the protections of the First Amendment and Article 16 of the Massachusetts Declaration of Rights. It is the view of this court that the defendant's conduct and speech, though a rather sophomoric expression of his opinion, is nonetheless protected speech. Protected speech, my friends. Imagine a judge in Massachusetts who thinks that your constitutional rights are important. I can't be more excited about this. And then his closing paragraph is my favorite, and it deserves like all the kudos to Judge Brian K. Walsh. I salute you. I bow down. Indiana poet James Whitcomb Riley, 1849 to 1916, may very well have been the origin of the duck test, coining the phrase, quote, if it walks like a duck, swims like a duck, ... end quote. I mean, is that a nod and a wink to Alan Jackson? I don't know. But that's where this whole thing came from. And then he goes on to say, in the instant case, a duck is just that, ... a duck. Free of allegations of foul play, FOWL play. I can't love this anymore. Quote, when the night falls, they swim to their little island and go to sleep, which is from a children's book called Make Way for Ducklings by Robert McCloskey, 1941. Accordingly, defendant's motion to dismiss is granted as to counts 1 to 4 only. XOXO, Brian K. Walsh, First Justice. December 9th, 2024. When night falls, they swim to their little island and go to sleep. I mean, mic drop. Come on now. that not the ducking best written decision that you've ever seen? And look, not to be outdone, because I knew I had it somewhere because I have 5 kids, you know. Here it is. Make way for ducklings. And this is hilarious because I recognized it when I saw it. And when I found the book, and it took me 2 minutes to find this book. Like I knew exactly where it was. Many of you might have read this to your children. It's been around since 1941. So I just read it quickly before I came on the air. And did you realize that this takes place in Boston, that these ducks were actually, uncivil. I was going to read it to you, but I don't know if we have time. But I think we could have story time one day. And it does say in here, because I had to go through it a little bit. Here, look. Here's the ducks. This is like when I used to go and read in the kids' classroom and like pick a book and bring it in and then show the pictures to the class. When they got to Boston, they felt too tired to fly any further. There was a nice pond in the public garden with a little island on it. The very place to spend the night, quacked Mr. Mallard. So down they flapped. And then they go to the State House and they fly over the State House. Like you couldn't script this any better, you guys. And they go to Lewisburg. I think it's Lewisburg. Is it Lewisburg Square? Look. So they flew over Beacon Hill and around the State House, but there was no place there. Oh. And then in the end, they go to Mike, the guy who helps them hold traffic for them. And then they have this little island. And the very last thing, the very last words in the book are, and when the night falls, they swim to their little island and go to sleep. I mean, come on. Brian K. Walsh needs a promotion. He needs to go up to the SJC. Maybe he should. Yes, he was. Hold on. Somebody said. I mean, when I would take my kids to the city, you know, because as one does, when you live on Long Island, you take your kids to the city, like to see the tree and do all that stuff, and just throughout the year for whatever. We go to the ballet, we go to a show. I saw my kids. I said, all right, you guys, you're like ducklings, all right? We're not walking 5 across on the sidewalk. You don't do that in New York City. We're like ducklings. And I would say, make way for ducklings. And I would have them line up. And the oldest kid would be in the front and I would be in the back. And we'd go single file through the city like that. And now my kids laugh about it. They're like, Ma, I went to the city with my friends. And they don't know you're supposed to walk single file on the sidewalk. They think that they could just walk 5 across on the sidewalk. And it's crazy. Make way for ducklings. Squirty Belly. Wasn't Judge Walsh the one who denied? No, he didn't deny. That was Judge O'Malley. Judge Walsh did deny someone else restraining order. I think it was Jem McCabe. You guys can correct me. I think it was Jem McCabe. It was that was O'Malley. That was Judge O'Malley who denied Chris Chris restraining order, HPO, whatever the hell they call it. Little Island is the island that all the kids go into Boston Harbor. Well, thank you. Thank you very much. People in the chat, you are the prize. You are the prize. All 2,276 of you, even if you're hate watching. And I know you hate watch me because I see you. I see you when you post your screenshots and people send them to me on all of the cesspool. And it's like you're watching my show. You're clipping screenshots from it. It's hilarious. And some of you aren't even making fun of me when you're doing that. You're just talking about the show and you're pretending that you don't watch me, but you do. These judges do have to be so tired. Kids in school, Sherry Max says, are actually bullied and traumatized, and they're in court over rubber duckies. Yeah. Yes. And a 60-something-year-old man who did that because he was, wanted something to do and he thought it would be fun for the kids to find around there. And Sandra Beatles fan says they have a statue of bronze ducklings in the public garden in Boston in honor of that story. That's amazing. Good Walsh is canceling out Bad Walsh. Thank the Lord. Except Bad Walsh has an E at the end of his name if you're talking about Brian Walsh. Right? Epic judgment this fine man provided. I agree. I'll allow it. I'm totally allowing it. Now, here's something else that's interesting. And Kurt just happens to be like a constitutional law scholar, so he might be interested in this. SR says, when you say XOXO, it scratches an itch in my brain. Oh my God, that's amazing. It's fantastic. All right. So, Kurt, I'm going to read to you. I'm going to read you this decision. So the SJC is the highest court in Massachusetts. The highest court in Massachusetts, as you know, because we watched the SJC arguments in the Karen Reed case, which happened all the way back on November 6th. Okay. That's when they did the oral arguments. The decision that I'm about to read to you was argued on October 7th. Okay. So that's going to give you some sort of an indication of how much longer we may need to wait for her decision. Or maybe not. Maybe it has nothing to do with it. Just know that this decision was argued 1 month approximately before Karen reads. And it is a decision in which the exact same judges are deciding to expand First Amendment rights in Massachusetts. And that is why it's so important. And that is way too bright. Let me just see if I can do something about that. What the duck? Can I make that smaller? I don't know. Doesn't really want me to. All right. So first thing to notice is that this is what they call a slip op. It's a slip op. It's a slip opinion. And that just means that it has not yet been officially published in those big law books that you see. Those big law books that you see everywhere. When you saw them when Michael Marcy made his hostage video in the summer, in August of 2023, all those law books behind him, all the law reporters were like upside down, out of order, missing. It was bizarre. And everybody pretty much doesn't use those books anymore, unless you're going to a law library. Then maybe you would. But I guess everyone now has Lexis and Nexus, unless they can't afford it because it's really expensive. And then some lawyers use ChatGPT to write their briefs. And then when they get busted, it makes a really, really entertaining case law, because that actually did happen in New York in federal court. And those lawyers were publicly shamed for using ChatGPT to write their legal briefs, because ChatGPT made up a whole bunch of cases that didn't exist. And when their adversary went to look for the cases, they're like calling them up and like, hey guys, these cases don't exist. I can't find them. And they're like, oh, well, I don't know. I don't know why you can't find them. And then they doubled down in federal court, and they were publicly shamed, humiliated. And I don't know if they were sanctioned and had to pay money, but it was super embarrassing. So a slip up is something that has just not yet been formally published. They can be cited, but it will be published. So people were confused by that. I heard some other people talking about it. They didn't know what it meant. And that is what it means. Okay. Which means it can be a little tweaked a little bit, but likely won't be. And so therefore, if you're going to cite it in something that you are citing in a case that you are on right now, you would just have to mention that it is a slip up or a slip opinion. Okay. All right. And this was in a case called Commonwealth versus Erickson Cruz. And you're going to see what's so interesting. Yeah, they are official enough. I know. But I saw people talking about it like, I don't know, maybe this means it's a rough draft. I'm like, nah, it's pretty good. Just the only reason you need to know that is if you were citing it in something. You're going to see what happened here. And you're going to see that this, what this guy did was far less, in my opinion, severe than what some other people have been doing that have been prosecuted under the same statute. And the court is now going to expand the First Amendment rights. So here. And here are the judges. And note that these are the same judges that heard Karen Reed's appeal. Judge Budd was the chief judge, Gaziano, Kafker, Wendland, Georges, and Dewar. Same judges. They're not afraid to expand the law or your protections under the First Amendment, and or perhaps other laws, and also not afraid to redo the jury instructions. So this was a complaint received and sworn to in the New Bedford Division of the District Court Department on November 25th of 2020. Case was tried before Kristen Stone. She was the judge. After review by the appeals court, the Supreme Judicial Court granted leave to obtain further appellate review. So I guess that's the way it goes in Massachusetts. You have to go to appeals court, and then you have to get special permission to go to the SJC, and then the SJC will either hear it with a one panel with one judge or 7. And here, this was the full panel decision as well. Here is the decision written by Judge Wendland. True threats, serious expressions conveying that an author means to commit an act of unlawful violence against the recipient generally fall outside the aegis. It's not a word you see very often. Aegis, how would you even pronounce that? Kurt, AEGIS, of the First Amendment to the United States Constitution. Whether words comprise a true threat is measured by an objective standard that turns on what the words reasonably convey to the recipient in light of the circumstances of their issuance. Nonetheless, the author's subjective mental state is relevant, whereas here the state seeks to punish the author. In particular, the U.S. Supreme Court recently determined in Counterman v. Colorado that the First Amendment requires the state to show that the author consciously disregarded a substantial risk that his communications would be viewed as threatening violence before it may punish him for conveying a true threat. The jury in the present matter, which was tried prior to Counterman, were not instructed that in order to convict the defendant, Erickson Cruz, for making a true threat, they needed to find beyond a reasonable doubt that he acted with the required mens rea. Mens rea goes to state of mind or intent. Accordingly, his conviction violates the First Amendment, further concluding that GLC 275 Section 2, threatening to commit a crime statute, survives the defendant's facial challenge, and that the prohibition against double jeopardy does not preclude a retrial in the present circumstances. We vacate the defendant's conviction and remand for a new trial. Yes, exactly. Exactly, Kurt. It's a decision making Massachusetts law consistent with federal law. Yeah. And these judges aren't afraid to do it, which I think is good news for Karen Reed. You can let us know what you think. And that the prohibition against double jeopardy does not preclude a retrial. But here's an interesting thing, because he was sentenced like 6 months probation. I don't know if they're going to retry it. I don't know. It's a little fakakta. Background, facts. And here's footnote 1. It says, because the defendant contends that the principles of double jeopardy preclude a retrial on the ground that the evidence was insufficient to establish the required mens rea under Counterman, we recite the facts the jury could have found in the light most favorable to the Commonwealth, and that is what they typically do. In 2018, the victim ended a 5-year-long dating relationship with the defendant. Following the breakup, the victim blocked the defendant's telephone calls on her cellular telephone and generally avoided communicating with him. Nevertheless, the defendant continued to send text messages to her. Occasionally, the defendant, who had lived with the victim during their relationship and moved out following their breakup, parked nearby her home. Approximately 2 years after the breakup, the defendant sent the victim 2 text messages. The first message was sent at 4:29 a.m. The defendant stated, in part, "I wish you all die, biatch. I'm so hurt and it still hurts. Duck you. I hope you die, biatch." And I'm just saying duck instead of you know what, because your kids are in the room. I know it. In the second text message, approximately 30 minutes later, defendant told the victim, "It hurts so much. It hurts a lot. Oh." Footnote 2. Yeah, I agree. 4:29 a.m. is not necessarily the best time for good decision making. Yeah. There should be like a block, like a block that you could put on your phone, like, do not let me text between the hours of this and that. That'd be great. Footnote 2 says the trial judge gave a limiting instruction that the jury could consider these 2 text messages solely in weighing whether the circumstances on the following day were such that the victim could reasonably have feared the defendant had both the intention and the ability to carry out the threat in the text message at issue. The following day, the victim and her band performed at a fundraiser at an adult daycare center. After the performance, the defendant's 2 children, with whom the victim had become acquainted during her years-long relationship with the defendant, ran to her and she hugged them. Later that afternoon, when the fundraiser ended, the defendant followed the victim as she walked towards her vehicle to leave. He was screaming and yelling at her. Approximately 2 hours later, the defendant sent the text message that formed the basis for the prosecution's case that he violated the threatening to commit a crime statute. Specifically, the text message stated, quote, "I swear to God, if you touch my keys one more time, I'll punch you in your ducking face, biatch. I'm not going to repeat myself again." The victim, who had not occasion recently to touch the defendant's keys, understood that the defendant was referring to his kids. Procedural history. B. Following a jury trial, the defendant was convicted of violating the threatening to commit a crime statute. So he was convicted. That's how broad their statute is. After his conviction, but while his appeal was pending, the Supreme Court's decision in Counterman issued. That was in 2023. It's a U.S. Supreme Court case. The appeals court affirmed his conviction in an unpublished decision. And footnote 3 says the Supreme Court's decision was not raised below. The defendant sought further appellate review, which we granted. 2, discussion. A, mens rea and true threats. As noted supra, true threats historically have not been protected by the First Amendment. The First Amendment does not protect conduct that threatens another. See Counterman, quoting Virginia versus Black from 2003, true threats of violence is a historically unprotected category of communications. Yeah, that's what I say, Santini. Always teach your children well. Teach your children well. True threats, like other types of potentially expressive activities that produce special harms, distinct from their communicative impact, were entitled to no constitutional protection, citing a whole bunch of other cases and things. Certainly violence has no sanctuary in the First Amendment. True threats are, quote, serious expressions of the speaker's intent to commit an act of unlawful violence. Whether words constitute a true threat is measured objectively, considering whether, in light of the attendant circumstances, the words justifiably cause the recipient to fear violence. Footnote 4, which says the term true in true threats distinguishes jests, hyperbole, and other statements that in context do not convey a real possibility that violence will follow. The term true threat has been adopted to help distinguish between words that literally threaten but have an expressive purpose, such as political hyperbole, and words that are intended to place the target of the threat in fear, whether the threat is veiled or explicit. Okay, where was that footnote? Okay. And it says whether the speaker is aware of and intends to convey the threatening aspect of the message is not part of what makes a statement a threat. And that, again, is from Counterman, a 2023 U.S. Supreme Court decision. The Supreme Court recently concluded, however, that the First Amendment shields some true threats from liability. Citing Counterman, again, discussing the chilling effect that absence of mens rea element might engender. A true threat may be punished criminally only if the speaker had some subjective understanding of the threatening nature of the statement. Specifically, to convict a person for making a true threat, the state must prove that the person acted at least recklessly. That is, the person is aware that others could regard his statements as threatening violence and delivers them anyway. B, jury instructions. Here, the jury were not instructed that they were required to find that the defendant acted with the mens rea necessary to convict him. As the law required before Counterman, the jury were instructed only that, quote, in order to prove the defendant guilty of threatening to commit a crime, the Commonwealth must prove 4 things beyond a reasonable doubt. First, that the defendant expressed an intent to injure a person or property of another now or in the future. Second, that the defendant intended that his threat be conveyed to a particular person. Third, that the injury that was threatened, if carried out, would constitute a crime. And fourth, that the defendant made the threat under circumstances which could reasonably have caused the person to whom it was conveyed to fear that the defendant had both the intention and the ability to carry out the threat. Jury instructions, yeah. Yup, they're not afraid. This SJC is not afraid to change them and rewrite them. And we talked about that a lot during the Karen Reed deliberations and after. Contrary to the Commonwealth's argument, these instructions did not require the jury to find that the defendant was aware that others could regard his statement as threatening violence and delivered it anyway. Accordingly, his conviction violates the First Amendment and must be vacated. Look what they just did. They overturned his conviction. Footnote 5. Where was footnote 5? The Commonwealth places particular weight on the second requirement in the jury instructions, which concerns whether the defendant intended his message to reach the victim. The intent to deliver a statement to a particular person is, of course, different from a subjective understanding of its threatening nature. See the difference there? The US v. Dodson, noting the difference between knowingly committing the actus reus, sending the threatening messages, rather than by accident or mistake, and Counterman requirement that the defendant be aware in some way of the threatening nature of his communications. C. Overbreath. The defendant contends that the threatening to commit a crime statute is facially overbroad. In determining whether a statute is facially overbroad, we look not only to the language of the statute, but to any limiting construction we have grafted on that language in interpreting the statute, citing a whole bunch of cases. Oh, a juvenile. Remember that case? That's been around a lot in the Karen Reed appeal. That was the double jeopardy, one of the double jeopardy cases. Unless it's a different case, because maybe there's a lot of juvenile cases. I'm not sure. And we have not hesitated to construe statutory language narrowly to avoid constitutional overbreath, especially where we discern a legislative intent that the statute prohibit only constitutionally unprotected speech. The threatening to commit a crime statute provides, quote, if complaint is made to any such court or justice that a person has threatened to commit a crime against the person or property of another, such court or justice shall examine the complaint and any witnesses who may be produced on oath, reduce the complaint to writing, and cause it to be subscribed by the complainant. And that's the general law, Section 275, Section 2. We previously have concluded that the legislature intended that this statute to reach only cases of true threats that would not qualify as protected speech. Consistent with that determination, and in order to effectuate the legislative intent to criminalize only unprotected speech, footnote 6, contrary to the defendant's contention, construing a statute to avoid unconstitutional overbreath does not require the quintessentially legislative work of rewriting state law, whereas here, there's no indication of a legislative intent to prohibit constitutionally protected speech. We construe the statute to require that the Commonwealth prove beyond a reasonable doubt, inter alia, which means among other things. Where's ipsi dixit? It's my new favorite Latin, ipsi dixit. That the defendant acted with at least a mens rea of recklessness, that is, that the defendant consciously disregarded a substantial risk that the communication would be viewed as threatening violence and delivered it anyway. Footnote 7. We also take this opportunity to provisionally revise the model jury instructions for this offense as set forth in an appendix to this opinion. See? There you go. Oh, there's ipsi dixit. Ipsi Dixit Sherilyn is here, and Ipsi Dixit Regular is here. Ipsi Dixit 1 and 2. Ipsi into chat. Look at that. Provisionally revising the model jury instructions. They're not afraid. Be not afraid, my friends. Be not afraid. The SJC is here. The SJC is here. Be not afraid. was going to make a little arrow, but it's not letting me. Going even a step further, even when they weren't asked to revise the jury instructions, they did it anyway. Accordingly, we conclude that the threatening to commit a crime statute is not overbroad. And then they get into some double jeopardy issues, and I don't know really if these are going to affect Karen Reed case because I didn't really read them. But here we go, double jeopardy. The defendant also maintains that the evidence at his trial was legally insufficient to permit a jury to conclude beyond a reasonable doubt that he possessed the mens rea required by the First Amendment, and that double jeopardy therefore precludes a retrial. We disagree. Rooted in the Fifth Amendment to the United States Constitution and in our common law, the prohibition against double jeopardy generally precludes retrial if the Commonwealth presented insufficient evidence at the original trial to support the defendant's conviction. The prohibition protects defendants against the possibility that prosecutors could treat trials as dress rehearsals until they secure the convictions they seek. Where the evidence presented at a first trial does not support a finding of the essential elements of the crime beyond a reasonable doubt, the prohibition against double jeopardy generally precludes a retrial. In short, the prohibition against double jeopardy precludes the Commonwealth from getting a second bite at the proverbial apple. In this case, the defendant's trial took place before the Supreme Court's decision in Counterman, which announced for the first time that the First Amendment requires proof that the defendant acted at the least recklessly. Noting Counterman newly instituted a recklessness standard for true threat liability. Prior to the Supreme Court's decision, it was established that true threats as a category were not protected by the First Amendment. The true threat was measured by an objective standard and could be punished thereby. So this Supreme Judicial Court, this SJC, is applying the U.S. Supreme Court decision of Counterman retroactively to a trial that happened in 2018 when this decision wasn't even rendered in Counterman until 2023. Following Counterman, however, some true threats will be protected. This is a change in the law. So again, applying it. Thus, at the time of trial, the Commonwealth had no reason to introduce evidence of the defendant's state of mind to establish his culpability for sending a true threat or to insist that the jury be instructed to include the mens rea requirement. Moreover, as a general matter, when we vacate a conviction, double jeopardy precludes a retrial only where the evidence at the first trial was insufficient to establish an essential element of the crime. Here, although the defendant was tried prior to the court's decision in Counterman, the evidence was sufficient to allow a rational jury to find beyond a reasonable doubt that he had the requisite mens rea. So therefore, he gets to be retried again because the law was different and because the elements of the crime viewed in the light most favorably to the prosecution could find a jury, could support a jury finding of guilty under these charges, he can be retried. But when you find out like what he did, so here it is. The evidence included that despite the passage of nearly 2 years since the victim ended their relationship, the defendant remained upset about the breakup. He knew where the victim lived, despite the victim's efforts to block communications with the defendant. He continued to send her text messages and occasionally to park his vehicle near her home. In the pre-dawn hours of the day prior to the true threat at issue, he had sent the victim 2 text messages. In the first one, he stated, "I hope you die, biatch." And in the second, sent just 1.5 hours later, he expressed desperation. A couple of hours prior to the true threat at issue, the defendant had followed the victim as she left the fundraiser, screaming and yelling at her as she moved towards the vehicle. Then in the text message at issue, he explicitly threatened violence against the victim, stating, "I'll punch you in your ducking face, biatch." In that same message, he warned, "I'm not going to repeat myself again." Viewed in the light most favorable to the Commonwealth, a properly instructed jury could have found beyond a reasonable doubt that the defendant consciously disregarded a substantial risk that his text message would be viewed as threatening violence and delivered it anyway. In these circumstances, double jeopardy does not prevent the Commonwealth from retrying the defendant. Conclusion: based on the foregoing, the defendant's conviction is vacated and the matter is remanded to the district court for a new trial if the Commonwealth chooses to pursue one. So again, I mean, I don't think they're going to pursue one. I don't think that there's any reason to. I think that he probably is already done with his 6 months probation, which was all he got as a result of his conviction. And so, do I think they're going to retry him? Probably not. Is it good for future defendants? Yeah. Because now you have to prove that the defendant knew or acted with recklessness in making those threats. Which is more of a burden on the Commonwealth. Here's what they did, and just sua sponte, revised the jury instructions on threat to commit a crime statute in Massachusetts. And they did this on their own, and here's what they're proposing. And they've added this 5th provision here for jury instructions. That the defendant was aware of or consciously disregarded a substantial risk that the communication would be viewed as threatening violence. This element requires that the defendant was aware that others could regard his statement as threatening violence, and yet the defendant delivered it anyway. And that, my friends, is another decision rendered on a different case, but was argued about a month before the Karen Reed appeal. Same court, same judges, not afraid to revise the jury instructions on their own and strengthen constitutional rights. So that's exciting. Kurt says, I think this decision is correct. You have to prove both the objective and the subjective. Makes sense to me. Yeah. And as you know from reviewing a lot of Massachusetts laws during the course of this Karen Reed case, Massachusetts in a lot of ways is very, very still back in, like, pilgrim times with regard to a lot of their laws. It's like the wild Northeast. So what had happened was this defendant, Cruz, was found guilty by a jury in 2022, and he was placed on 6 months probation. He was ordered not to have any contact with the woman. He appealed the verdict, and the SJC chose to review the case. Records show, this is according to the Boston Globe. I mean, he's already done with his probation. Will they choose to retry him? I don't think so. So there's that. Cruz was a 37-year-old Fall River man. Fall River has entered the chat again. Wonder if he has a Fall River accent. And there's that. And interesting, because it was not a heinous crime, right? It was a, I'm going to duck and punch your face crime. Sherry, thank you for the 5. My 8-year-old granddaughter had a cheer group competition today, and they were sneaking good luck ducks into each other's bags. Oh, that's so cute. Criminals in training. I don't know. It depends on where you live. Do you live in Massachusetts? I won't tell. Be careful, Sherry. My most favorite place to be, says Mama She. Thank you for hanging around with me for 4 months. And Squirty Belly says, jury instructions? We don't need no stinking jury instructions. No. But maybe, just maybe, they'll expand their jury instructions to say something like, in the event that you do not come to a decision on count 1, please let the judge know. Please let the judge know that you can only, please let the judge know if you have reached a verdict on any of the counts, because she didn't say that in her instructions in the Karen Reed case. She said, until you have reached unanimity on all 3 counts, do not come back to me with any sheets filled out at all. It's exactly what she said. And they weren't asked to revise the jury instructions in this appeal, and they did it anyway. So there's that. Oh no, this is a Colorado jersey. Because Travis Hunter won the Heisman, and it's a Travis Hunter jersey. So we got some buffs emojis in the chat for Cheryl Ellis. Look at Denise. Denise said, I wore my free Karen Reed shirt to Target today. I just so happened that the MSP was there collecting toys for tots. She says, I bought toys and broached the ducking subject. One trooper walked away. Oh, no, you didn't. They're going to come after you for threatening and harassment. Maybe even littering. You never know. You never know. Seth says, I highly recommend watching Dream Feed Media. Last couple videos on Harry case. I don't know. I don't know who that is, but a lot of people are bringing it up. So that's interesting. I don't know who that person is. Does anybody know who that person is? They need to understand reasonable doubt. Yeah. There was another case that we watched in Mississippi where the defense attorneys asked for an instruction on reasonable doubt. And the judge said, no, everyone knows what reasonable doubt is. I don't need to tell them what reasonable doubt is. They all know. And then we watched the Daniel Penny trial, and those jurors came out and did ask for some clarifying instructions. Can you tell us again what reasonable doubt is? Can you tell us again? And in New York, you can get all the readbacks you want, and they give them to you. But not in Massachusetts. They don't. They sure don't. So, oh no, they don't. Comments, thoughts, questions, concerns, anything else you want to talk about? Like episode 10 of the Phelps podcast. Anybody want to talk about that? Anybody have thoughts on that? Anybody listen to episode 10 of the Phelps podcast? Because there was a lot of stuff in there that was bizarre. I don't have my notes, but I did listen to it. So if you refresh my recollection about episode 10 of the I Hate Turtle Boy podcast called 34 Fairview Road, please tell me what you thought about it. I mean, there was here's what I think was great, actually, for the defense, is that apparently a juror spoke to M. Phelps, or I'm sorry, I forget his name, M. William, whatever his name is, Phelps, and they disguised his voice, and he spoke on the podcast, and he said things about jury discussions and what they were talking about in the jury room. And that is going to be hugely helpful to the defense. So thanks for doing that episode, and thanks for interviewing that juror, because all the stuff that the juror said is completely going to help the defense in the next case, right? In the re-persecution, right? So tell me some of the things that juror said, because now I can't recollect them off the top of my head. Squirty Belly says, I have reasonable doubt that everyone understands reasonable doubt. I know, me too. Lots of lies were told. Yep. It's not about the case. That podcast is all about I Hate Turtle Boy and how bad Turtle Boy is, and Turtle Boy's a monster, and how, I mean, it was like, if you listened to that podcast for all 10 episodes and you didn't know anything about the Karen Reed case, you would leave that podcast saying, I still know nothing about the Karen Reed case. What happened in that trial? What happened? You still wouldn't know. Thank you. Thank you, Red Pen. Can I say that you're the most fluid reader of legal documents? Yes, of course, I'll allow it. I love listening to you read them because I can follow along perfectly. Thank you. Some people, I think I read too fast. And then I just say, you can slow it down on your end on the replay. Also on the replay, you can use your closed captions, which helps. Thank you very much. Yeah, it was absolutely an I Hate Aiden episode. Kimmy, thanks for the Canadian 5. In Canada, we can't protect ourselves. If you go against the perp, we get prison. Really? So you have no self-defense? No stand your ground? Teddy Bear, what did the jurors say? You guys chime in on what the jurors said. The jurors said all kinds of crazy stuff. Like, the first thing we did when we went in there is we were trying to decide if he was hit by a car. And then, he said a lot of stuff about the text stream data. Like, they were apparently, according to this guy or girl, I don't know, because the voice was disguised. So we don't know if it was a man or woman, said, we knew that the car did the thing in reverse according to the text stream data. So I think next trial, it's going to have to be spelled out, because based on a lot of analysis that I've seen from people who actually really know what they're talking about in interpreting this text stream data, that key cycle event with the 24 miles in reverse or whatever was not done by Karen Reed. It couldn't have been. No way, no how. You guys fill in, please, for Teddy Bear. Costco says, I don't understand why Melanie isn't at 100,000 subscribers already, but I can only subscribe one. Yeah, everyone just hit the subscribe button. It's free. Great way to help the channel. Another great way to help the channel for Christmas. It doesn't cost you anything. Shop through my Amazon link. It's linked in the description below. Just buy your regular stuff. It doesn't have to even be the stuff that I suggest that you buy. Just if you click on my link, do your regular Amazon Christmas shopping. It helps the channel. Thank you. But he didn't publish what the Turtle Boy cult juror said because it didn't further his narrative. Yeah, it was a Turtle Boy hit piece is what it was. I don't know where all of this hatred for Aiden came from. And this is not like, we're not here to defend Aiden, like bash this guy Phelps or whatever, but it was so obvious. Like, and here's what's really weird, Risa, about it, is that Aiden Carney and William Phelps, I'm sure, I don't know, whatever his initial is, we'll just call him Phelps, have the same talent manager who also happens to be an attorney. And he's the one who brokered the deal for Aiden to work with Phelps on this podcast called 34 Fairview that apparently Aiden thought was going to be like pro Karen Reed, because that's his position, right? Pro Karen Reed. Like, hey, if my manager is setting me up with this guy who's also managed by my same manager, I imagine that our interests are aligned. Well, it couldn't have been further from the truth. It could not have been further from the truth. All kinds of random people were interviewed, people who are really going to help the defense. He interviewed, like, he has 100 hours of tapes, which can be sought after. That might have all kinds of exonerating information in them contained therein. VSPC says Phelps completely lost the plot in that episode. I'm going to say it started in episode 3. I did another show on this where we went through episodes 1 through 9 and talked about them, briefly. We didn't listen to it together or anything, just small portions of it. I think at episode 3, it kind of took like a sharp turn into, this is all about protecting the witnesses in this case. And I hate Turtle Boy, and here's why he's so horrible. And really, really said some very like defamatory things about him in episode 10, right? Episode 10 is one that just came out, and it's like the end. And Cheryl Ellison, I think the fact that Turtle Boy makes 40% off of the anti-Turtle Boy podcast is both suspect and hilarious. It's like poetic irony is what it is, right? It's bizarre. It's bizarre. The altered voice sounds like Neil deGrasse Tyson. I don't know who that is. Belly, who is that? Gray Space says the quotes from the juror were like spliced in some parts, clearly right, which isn't that even more reason to seek the 100 hours of unaltered tapes of all of these dozens of people that he says he interviewed. I mean, look, there could be some exculpatory information in there, right? Similar to the motion that the prosecution has made, that the Commonwealth has made for all of the notes and cutting room floor excerpts from the Gretchen Voss Boston Magazine article, which they were just given all the off the record stuff. You know what's really weird about that is that the judge ruled on that decision, and we never went over the papers in opposition that were filed by the Boston Magazine, because they weren't even docketed into the court file until after that decision had already been rendered. That was weird. If anybody knows, they know. Tell me why that was. They didn't know what time the cert team was there, right? That was part of the stuff that the juror said, right? He said something like, yeah, we asked for the cert team reports. And then he starts talking about the cert team reports. And we're all thinking to ourselves, probably, at least I was, there weren't any reports. There were no reports about when the pieces of taillight were found. It was not documented, right? There was no evidence log. So I was confused about what he was talking about, because the court told him you can't have it. And the reason that they couldn't have it was because it didn't exist, right? Tell me if I'm crazy, because, we've been gaslit a lot in this case, and I quite possibly might be crazy. And then he was saying things like, oh, yeah, so we figured out that according to the cert report, like this person got here at this time, and these people were on scene, and this is when they started finding. But it was like maybe they were relying on their notes because there was no report from the cert team. I remember when that note came out and she told them, no, you can't have it, or you have everything you need, or something like that, right? The ending was the funniest part. Refresh my recollection. Where does perjury fit in here with regard to whom? Linda Mon. Perjury is testimony under oath, when you lie under oath on the stand about something. So it wouldn't have anything to do with the podcast at all. FTR, what a juror for the record. Oh, I thought that made a little cupcake. What a juror misunderstands regarding evidence is not evidence. Yeah, and also when they're back there and they can only rely on their notes, right? Because that's the only thing they could rely on. No readbacks, no extra evidence that doesn't exist, or it's not going to reveal itself now. everyone's notes are going to be all fakakta. And then they're arguing about what's in their notes. And they're like, no, in my notes, it says that they got to the scene at 5:15. And so therefore Proctor said this and this person said that. And so therefore it couldn't have happened. But meanwhile, everyone's got different notes. I look at my notes sometimes, I can't even read my own handwriting. Imagine if for a 9-week trial. Oh, Kurt thinks I'm a good reader. Thanks. And James says juries terrify me. Gray spaces, I talk at the perfect speed for his or her ADHD brain. No, it's not a Saints jersey. This is a Colorado jersey. I'm sorry. It probably, maybe it's the same colors. But look, Pac-12, number 12, Hunter. Okay, Risa says he was basically asking for Turtle Boy haters to call tips into him at the end. That's what it was. Yeah. Anybody who's been threatened by this guy, call me, get in touch with me. I can drop another episode of this podcast at any time. It was mind-blowing. I mean, if you listen to nothing else, just listen to the last episode. I listened to all of them because I just really wanted to hear who he was interviewing, what they had to say, who the spokespeople were for the McCabe's and the Alberts, and what his 100 hours of interviews might contain and whether or not perhaps they could be helpful to the defense. And I think they absolutely could be. Carol's mind is blown. Podcast is obviously so slanted and absolutely 100% subjective. It says VSPC, very serious podcast consumer. Kate said, Phelps sounded like mainstream media. He didn't even bring a new bad take on the case. It was like, but like, we all know so much about the case that for us, we could at least follow along. Like people who knew nothing about it and were coming in like naked, let's just say, to this case, we still wouldn't know nothing about this case when they were done. Yes, MLC, they wanted to know which law enforcement officers were there. The jurors did, right? They wanted to know which officers were there when they started finding taillight pieces, right? And there was no list. There was no log. There was no attendance sheet. In fact, whoever was on the stand said something like, yeah, a couple guys were there. He was in charge of the scene, like the guy who was in charge of the scene. When I say scene, I mean 34 Fairview at night after it was unsecured all day during a blizzard. He said there were a couple other guys there in plain clothes, and I assume they were law enforcement, but I don't really know. Right? So who knows? Who knows? What did the juror say? That's the kind of stuff that he said. And so it was like texting. Wait, I'm really behind in the chat. Hold on. Yeah, and the judge always says, you may take notes, but don't rely on them. He thought Jen McCabe, right? Patty Minko. He thought Jen McCabe was an attractive soccer mom, so she couldn't be lying because she was a soccer mom, right? Gracious Rebel says, Phelps is looking to find Aiden guilty of something. Patriotic Act knows what I'm talking about. She's picking up what I'm laying down and says, thank you, Phelps. Very helpful. Jamie says, I doubt there is a real juror anyway. Doesn't sound like a really credible source. Haven't seen it myself, but from what you're saying, so defense will probably weigh authenticity carefully. I think what you should do is listen to it. It's audio only. So it's not, there's no video. It is audio only. You can find it on Spotify or Apple or wherever you listen to audio only type podcasts. I would imagine that he had to vet it thoroughly, and it probably is a real juror. From the way this person was speaking, it sounds like this person may be the foreman. But what this person never did say was, oh, and by the way, we really did not acquit her on counts 1 and 3. No, never said that. They put a lot of weight onto that text stream data. Take your blood pressure pills before you do it. But just do it like for like a little homework. You can't listen to it, but just episode 10, listen to what the juror has to say and let me know how you think that is going to help Karen Reed's defense team retry this case and what they're going to focus on. Right? Just south of history says the judge said you have all the evidence you're going to get, essentially. Yep. Mrs. Jim Morrison is in the chat. People are strange when you're a stranger. The jurors did listen to the evidence or lack thereof, not solve any crime, and or convict for sympathy for the families. Linda says, I was wondering about this case and all the lying. How are they not perjuried? I'm sorry, I'm learning to speak the law. Because we don't, well, we don't know, like, who lied about what. We'd have to be able to, I guess they'd have to be able to prove, first of all, perjury is rarely prosecuted. Second of all, you'd have to, like, we don't know if there's anybody who is absolutely lying yet. I mean, there's no, I don't think, there's no perjury that can be prosecuted yet. Are you following what I'm saying? So, I'm not seeing anything right now that they would, I mean, it's the Commonwealth who'd have to prosecute it. So, like, or the feds. I don't think the SJC will modify the no readback rule. I don't know. That's a good question. The SPC. That's a good question. I don't know that it's, I don't know if they're hearing any cases that in which that was an issue. In which case they may, because we don't know. I mean, you can watch them out there. They have a channel on YouTube where you can watch the SJC every week and you can watch the oral arguments of every case. So I don't know what other cases they're listening to or what other constitutional issues they're taking into account right now, but who knows? Jamie says the judge should have said there is no report. Otherwise it's misleading. And there is a report. Yeah. And then could have also said they can't have anything else. Right. And Patriotic says the no readback stuff seems criminal, designed to confuse the jurors. Yep. That is correct. Lori said, I'll never believe anything from Phelps again. Had you listened, Lori, to his other podcast? Because apparently he's also written like 50 books and did a couple of other podcasts too. I wasn't familiar with him until he did this one. So I didn't really have like I didn't have an opinion going in. He called Aiden a criminal. Yep. Yeah. Brian Higgins may or may not have called into the JFK podcast. Yep. Calling himself Kevin from Southie. Thank you, Rosemary. Mm-hmm. John Doe, does perjury include lying to police and sworn statements? Well, there are no sworn statements in this case. There are none. Because all we have are statements that Proctor authored himself. He had no notes. He wrote them sometimes months later. They're not sworn to or signed by any of the witnesses here. So it doesn't even apply. Perjury could apply to, if you're signing an affidavit that's notarized and you're swearing that it's the truth. Yeah, it could apply to that as well. But in this case, there wasn't any of that. Because even some of the witnesses on the stand said, oh, I didn't write that down. I didn't say that. And Proctor must have wrote it down. He must be wrong. Or Goody or whoever wrote the report must be wrong. I didn't say that. Seth says Phelps really hated the Vanity Fair piece. Mentioned it a couple of times. Yep, he did. This is true. Security Belly, I thanked you for this. I have reasonable doubt that everyone understands reasonable doubt. Hello, Romy. Thank you for the 10. In the podcast, Phelps says at 34 Fairview, the women were upstairs and the men were downstairs. I want to know who told him that because it contradicts witness testimony. Yeah. Uh-huh. He did. And I went over that when I went into over the first 9 episodes. Thank you so much for the 10. He says, but the way he said it in the podcast is, according to the testimony at trial, the women were upstairs in the kitchen dancing and playing videos and having a grand old time while the men were downstairs, probably discussing things like sports and their kids. Well, we know that wasn't the evidence at the trial. There was no testimony to that effect. In fact, at one point, Brian Higgins says, oh, no, I never went upstairs in that house because Brian Higgins said we went upstairs to look at pictures of my son in the Marines or something. Brian Higgins was questioned about whether he ever went to the second floor, and he said no. So what did Brian Albert mean? We went upstairs from the basement to look at the pictures of my son in the Marines? Because at one point, this is just all coming to me now, putting together the pieces, Nicole Albert says, oh yeah, I walked into the other family room or living room, and they were looking, Brian and Brian were looking at pictures of my son in the Marines or whatever armed services he was in. So were they downstairs in the basement and they came upstairs to look at the pictures? And that's when Nicole, who was frantically cleaning all the time, went into that family room? That kind of clicks now, doesn't it? So somewhere in that 100 hours of interviews, there must be at least one or more people saying the men were downstairs in the basement and the women were in the kitchen looking at It's Raining Men videos and looking out the window and texting John 400 times and calling John 17 times, right? That's right. MD says right. BA said they were upstairs and Brian Higgins says downstairs. They came upstairs to look at pictures because Nicole confirmed that. But according to Phelps, he must have talked to some people who said the men were downstairs talking about sports and kids and things. Right? I mean, even Kat says, I questioned that during the trial. Both Brians had different stories. Yep. And we don't think he watched the trial, right? Because Oh Sweetie No says, how dare you expect that dude doing a podcast to watch the trial? I don't think he watched it. I think he got all of his information from these 100 hours of interviews that he did with people who were all very much so anti Karen Reed. Thank you, Sarah, who says, please listen to Dreamfeed Media. She has 3 streams, Miracle on Fairview. All right. And give us your thoughts. She's amazing. Oh, thank you. Thank you very much. Thank you, Sarah. I will listen to that. And also a question from Mariana. Thank you very much for that. Oh, you're a sweetie. Thank you, sweetie. I appreciate you. Allie says, free Karen Reed, free Turboy, free the Ducks. Thanks for covering this. Thanks, Allie. And then there were none. Thank you for somebody anonymously who bought me coffee, and also for Justin Green sending me a cash app. Says, thank you for being here 7 days a week for us. Well, you know, I love hanging out with you guys. It's what I like the most of all the things that I do. Well, you know what I mean. VSBC, thanks for the 5, says, I'm not convinced Phelps and Valentinus weren't hired by an anti-Karen Reed entity to get their hands on Aiden's research. Yeah, that was something else that he said. He said, I gave Aiden Carney a hard drive and told him to give me all of his documents and all of his research onto that hard drive, and he didn't do it. No, did you think that he would? Just give you all of his work product? I was so confused by that. If anyone who, ambulance driver, thank you for the deuce. You wrong. Kevin from Southie, coming in again. Joseph Kane. 20 butt dials over 24 hours is perjury. 20 plus butt dials. You'd have to prove him wrong. I mean, who knows? Who knows what's going to happen next? Anybody want to? I mean, does Vegas have odds on this? Anyone? Bueller? Anyone? Leslie, Karen Reed's team needs to hammer in that any other theory makes more sense. Don't put all the theories in one basket. Right. Or, and here's another problem, Leslie, too, is that they only had an hour for closings. That was nowhere near enough. This was 9 weeks of trial. 1 hour was a joke. It was a joke. If you were sitting back there in the jury room trying to figure out another way that this happened, that is reasonable doubt. If you were sitting back there trying to figure out what happened to John O'Keefe's arm, that is reasonable doubt. Because the only thing you need to decide is whether or not Karen Reed hit John O'Keefe with her car. And if you don't believe that happened because the injuries don't pan out, stop. You're done. It's not guilty. That's it. That's the end. It's really that simple. But according to this juror who was on this podcast, he says that they did think she hit him with the gun, but I don't know if this guy is speaking for all of them. Like, we don't really even know. So it's just weird. But I think that a lot of the stuff that he said during that podcast is stuff that the defense needs to hammer in on. Right. And also make the jurors know that the defense does not have to prove anything. This is not our burden. This is their burden. This is their burden. The Commonwealth has to prove to you that John O'Keefe was hit by a car. That's what they have to prove to you in order for this entire case to stand on its legs. And ask yourselves this: did Trooper Paul convince you that Officer John O'Keefe was hit by a car? Did Squirty Bello convince you that John O'Keefe was hit by a car? She couldn't say he was hit by a car. She said his injuries were not consistent with a fight, which is a bizarre thing for a medical examiner to say. She couldn't say how those injuries happened to his arm. She couldn't say how those injuries happened to his head. So did the jury really buy the pirouette theory? John O'Keefe was hit like this. His arm was like this. He got hit by the tail light. He spun around, flew 33 feet, and cracked the back of his head open on frozen ground. And no other part of his body was struck by the car? Everyone. I mean, you don't have to be a lawyer, an injury lawyer like I am for 30 years to know that when a pedestrian is hit by a car, there's bumper marks and bruising to the legs, knees, ankles, hips. Usually broken bones. And I'm going to tell you that if you're hit at 24 miles an hour in reverse, which, by the way, don't try it at home, but try it at home. Because when I'm backing out of my driveway and I get past 5 miles an hour in reverse, my car starts beeping and is like, stop, you're going too fast. 6 miles an hour, it's like, stop. And it does seem fast at 6 miles an hour. So try to do 24 miles an hour. People have tried it. Don't blame me if you get hurt. Don't do it. I'm just saying. Anybody ever hit a deer? See the kind of damage that does to your car? This is just common sense stuff. You ever know anybody who got hit by a car as a pedestrian? Because if you were hit at 24 miles an hour, you'd go flying. And landing on the ground would cause its own set of injuries. But being hit by the car initially would also come with its own set of injuries, broken legs, fractured everything, fractured femurs, perhaps, fractured hip. I mean, at least a torn meniscus. Show me something. Got nothing. People Marcy Sketty's name. Trooper Paul said he increased the Yamaguchi triple lux style across the yard. Yeah. Right. Katie says my mother hit a deer in her SUV. It was completely totaled. Yep. Brick Gal says that's a great point someone just made. Jen McCabe kept asking her, are you coming? However, never texted him to say, why didn't you come? We were waiting for you. Yep. Also, Higgins texts John at 12:20 or something. You can correct me on the times. You coming here? You coming here? At the same time that Jen McCabe is giving him directions, park behind me, right? Sees him outside, then keeps calling him, is looking out the window every second, sees Karen Reed pull away, she says. Sees Karen Reed leave. Never saw a body on the lawn. I mean, there's just so much things that strain credulity here. It is common sense, PJ. I am not an orthopedic surgeon qualified to talk about car strikes, but I have represented hundreds, if not thousands, of clients who have been hit by cars as pedestrians and who have been bitten by dogs. So there's that. Somebody made a good point, and I forget who it was, that Dr. Russell is not necessarily a dog bite expert per se, but somebody said causation expert. I don't really like causation expert as a term, and I can't remember who it was. But I would say she's more of an injury expert to opine where these injuries came from, not necessarily calling her a dog bite expert might be like a misnomer, but calling her a doctor who can identify injuries of all types might be a little bit better. He said a causation expert. Was it Peter? Yeah. And that makes a lot of sense too, like causation, like what caused these injuries? And Peter's an injury lawyer. He knows. Definitely a trauma expert, 100%. Medical trauma expert. Yeah. Yeah, a wound expert. Yep. Dawn says, I was hit by a car years ago. Not only did I fly up over the hood, but shattered a bunch of ribs, bruises. Yeah, you know. And how fast was the car going, Dawn? Like, we saw what happened when didn't Chief Helena Rafferty hit somebody in a crosswalk, a pedestrian, at a very low rate of speed, and he broke all kinds of bones and had a lot of surgeries? Right? Didn't that happen? Thank you, Dawn. Oh, sweetie, no, says I got up to 16 miles in reverse, 16 miles an hour in reverse and gave up. It was terrifying. Mm-hmm. I haven't read any books on dog bites. Nope. None. Litter beauties, and it's insane that any jury would not put it all together and think that that car hit him. That is what boggles my mind the most. I know. Donald Duck says, I'm not a vet, but I know a dog when I see one. Stephanie says, he's just a paid writer. In the documentary world, we call them fluff pieces or writers. Yeah. Kate says, do you think the defense should back off the third party culprit? I don't like constantly hearing Karen didn't prove a conspiracy. I know she doesn't have to prove anything. I think, maybe a better theory would just be, we're not really sure what happened. What we are sure about is that Karen Reed did not hit John O'Keefe with her car. What we are sure about is that John O'Keefe was not hit by a car. Something else happened. Don't know who did it. Don't know what happened. Could have been an accident. Could have been a lot of things. But the evidence shows she was outside that house and she pulled away because Jen McCabe will tell you she pulled away. And when she was gone, nobody saw a body on the lawn. And the evidence is also going to show that she connected to the One Meadows Wi-Fi at something like 12:36 p.m. Why did Lally say in his opening that Karen Reed hit John O'Keefe with her car at 12:45 if she was already home by 12:36? Something happened, but Karen Reed did not hit John O'Keefe with her car. And it's not their job to prove what happened. Right? Straight reasonable doubt, says Jonathan. Less on third-party culprit. And they can change their defense. And I think they have very, very strong evidence that thought that was a dog attack. And the dog attack happened while he was alive. And he wasn't attacked by a dog in Karen Reed's car or in the parking lot at Waterfall. And they made specific mention in all of the witness statements. Every single person who saw John at the Waterfall or at McCarthy's did not see any injuries on John. And I think the cross-examination of Dr. Renee Stonebridge needs to be stronger because Dr. Renee Stonebridge will give them everything that they need, every single thing that they need. Brainstem herniation, multiple hemorrhages in different parts of the brain coming from a right, a left, a head, this, all different incidents. Not just one smacking your head on some frozen ground. Didn't cause all the frontal lobe injuries and the temporal lobe injuries. Those came from something else. And Dr. Renee Stonebridge can put it out there on a silver platter, and she's the brain doctor who works for the Commonwealth. Let me at her. Put me in, coach. Put me in. I'm ready. Yeah, I don't think they crossed her at all, right? Medical facts and physics, right? Kate says also Hank misrepresented Dr. Russell. She said she was an ER orthopedic expert, not a specialist. Yeah, he was grasping at straws. Are you an orthopedic expert? No, but I can read an X-ray. Oh, so you would say you're just going to anoint yourself an orthopedic expert? She's like, no, but I treat broken bones in the ER, thousands of them. So, if somebody was treated in the emergency room, I could testify that they had a broken bone. Not an orthopedic surgeon. That's a specialty. You have to be board certified to be a surgeon, but I can definitely tell you about a broken bone. Quack, quack, duck says, quack, quack, quack. The home Wi-Fi connected is the thing I can't get around. Lori Marie, flip the script for a second. Imagine the Commonwealth were to attempt to call an orthopedic expert to testify. Would anyone, including the Commonwealth, see any relevance in that? No. I think he was just being facetious when he was asking her that. Right? Because he didn't have any orthopedic injuries. So where was he going with that? He was just saying, oh, so you're just going to anoint yourself to be whatever kind of expert you want to be, just because, you worked in an ER and you worked in a prison where you saw like millions or however many, over 500, like dog bites. And a lot of those guys were prisoners that were attacked by, police trained dogs that were like dragged to the ground. And like, that's how they were apprehended, because a canine went after them and like bit and held and dragged them to the ground. I thought he was just being facetious with that. We got some justice this week. Oh, sweetie, no. We got justice for Richard Schiffer. Well, that was like last week. We got justice for Daniel Penny. And we got justice for Brian Camp. And if you guys do not know about the Brian Camp case, go back and watch that trial. I did a whole series on it. We stumbled upon it one day when we were waiting for Aidan Carney's hearing to come on. We couldn't find it, and it wasn't televised. And then I said, I saw opening statements on this case called Brian Camp. That's up in Hampshire County. Have you guys heard of it? Nobody heard of it. Brian Camp was a 23-year-old kid sleeping in bed with his girlfriend. His kids were sleeping in the next room, and a crazy mofo broke into his house and was standing in his bedroom doorway trying to kill him. And Brian Camp, who was buck naked, this guy jumped on top of him, started smashing his head against the wall. Brian Camp defended himself, shot the guy, killed him. They tried him in Hampshire County. And he was acquitted. And that was a great day. So please go watch that trial. Not enough people knew about it. Yeah, he was trying to say if he could get a rise out of her, previewing her. Yeah, trying to push her buttons. It didn't really work. She was on the stand for the entire day. I mean, there are people half her age that can't be on the stand the entire day without like collapsing. She did an amazing job. How great was the moment Her Majesty Dr. Russell said, I don't see any degrees. Yeah, I don't know what that book was. I really didn't do any more research into it. The SPC. But yeah, 2025 is going to be the year of justice, says Patriotic. If you know, you know. I Wasn't Born with Thorns says, has anyone watched the Netflix documentary American Nightmare case where they blamed the victims for faking a kidnapping because of a movie script? Well worth the watch. No, I have not watched that. Should I put that on my list of things to watch? If you don't know, the Dexter new series has started. It is Dexter, the prequel about Dexter growing up and becoming a serial killer. And Christian Slater plays his dad. Episode 1 is out. It's on Showtime. And maybe Showtime and Hulu, are they the same thing? I don't know. But it's really good. Sometimes you need to step away from YouTube, peeps. You just do. You just do. Ms. Holmes, thanks for the 5, says, I read many of Phelps' books, Audible, and I used to like and respect him, but the way he turned on Turtle Boy and the truth of this case, I wonder about all those books. Thank you for the 5. Dawn, I think we covered this about being hit by a car and flying over and breaking all the ribs. Thanks for the 5. And Squirty Belly says the book that Brennan had was written by 2 dog behavior specialists, right? But not the one that they have proclaimed as their expert, right? James Crosby. And what is a dog behavior specialist going to say? Chloe never would have bit anyone, but we know Chloe bit someone because we have a photo of it, number 1. And we know that Chloe attacked a dog in 2018 and almost killed the dog, right? So if a dog is not even involved in this at all, why is the Commonwealth even going to call a dog behavior specialist? To say what? I mean, either the dog was involved or the dog wasn't involved. Like, it's very bizarre to me. I have no idea why they would call that guy Crosby. My nurse Cal, thanks for the 5. Dog injuries go to the vet. Humans to the hospital. ER doctor is a pro at all trauma injuries and to recognize, stabilize, and send to correct specialists. Duh. Yep. Yep. You're correct. I know. It's common sense, Cal. Cal's a nurse. She knows these things. Thank you for the 5. I'll allow it. Says if those aren't dog bites, you don't need a dog behavior specialist. No, but again, what is this guy going to even say? Chloe was a nice dog. Chloe never, they've already testified at trial that Chloe wasn't good around strangers. Right? It's just bizarre. I'm scratching my head on this one. Jimmy says the book that he showed was written by a vet and behavioral expert on animals. All right. I didn't read it. Dog behavior specialist cannot speak to dog bite patterns, says Ipsy Dixit Sherilyn. They need a prosecutor behaviorist, says not that Susan. I don't know. A lot of people are clueless as well. I wish somebody could explain it to me. Austin says, in my opinion, the cuts on John's arms are from the whiskey glass he was holding when he was backed into. He landed on top of it and slid against the concrete, cutting his arms. I can't tell if you're being facetious or not. I think if you slid it across the concrete, against the concrete, I think your arms would be more like scraped, like a road rash kind of thing. These were like, like lacerations that were like in patterns. So I see it differently, but I appreciate your opinion. Big Old Dog, if you listen to their dog expert, he describes Chloe when he talks about Vicious Family dogs. Yeah, we listened to a little piece of a clip that we found of him on YouTube, which you can find if you just search up his name, like James Crosby, dog expert, or Jim Crosby. Joseph said, I thought it was a biting Lexus. Yes. Seth, the defense can voir dire or ask for a Daubert hearing on the Commonwealth experts. Why haven't they? Their time to do their discovery doesn't start until the Commonwealth has given them every single thing. So there's time. Once the Commonwealth files their certificate of compliance, then the defense can be like, okay, here's what we want. We want to have a Daubert hearing on your guy, Shannon, who doesn't know the difference between a gigabyte and a gigabit. And also, like, let's get like Trooper Paul in here, and also like a couple of other people that you had testify as experts who are clearly not qualified. And also the fact that they let Yuri testify about where his injuries came from. Like, really? Why was he allowed to give that opinion on the stand? Why was that inverted video even allowed into evidence? It was almost like the rules of evidence didn't even exist. And that's the reason why all of these sidebars need to be transcribed and released. It's going to take those poor court reporters day and night for months to even transcribe all those sidebar. Because that's where everything was argued. Nothing was argued in open court. So we don't know what any of those rulings were because they were all sidebar. Mariko, is all this dog talk by the Commonwealth to try to have those tooth marks masquerade as car damage? Not unless the car is a transformer. Well done. Well done. Risa says, Hank doesn't seem that bright. I don't get what the big deal is or was with him. Unimpressed. I don't know. People think he came out swinging when it came to Dr. Russell. This was the first time that anybody, including us, if you didn't watch like the Whitey Bulger trial, and I don't even know if that was televised, quite honestly, has seen him, in this case anyway, question a witness. And now we have an idea about what his style is like. He's very aggressive and he's very sarcastic and dismissive. I thought he was to Dr. Russell anyway. I don't know if he's going to be like that with every witness, but we'll see. The Cupcake says, an expert who can answer stuff like, isn't it true that sometimes this doesn't mean that, and other flimsy concepts to confuse the jury? Yeah. Because things just reveal themselves and, things just reveal themselves and evidence just reveals itself, and because it just did. And then Grace is like, no way, those are not glass cuts. There would have been glass in there. I know. Or taillight pieces. Pieces of the taillight would have been in there, but. Drunk on drugs. Well done. Well done. You changed that. I see what you did there. You changed that after he said that, drunk on drugs, right? Wasn't that a Brennan quote? The fibers say you wrong. You're wrong. The fibers say you wrong. Yeah, because the dog's tooth went in and then the dog's tooth came out and then that's when the fibers pulled out. I mean, one needs to go no further than to look at the clothing. Look at the marks on the clothing. Tooth marks, right? So if they were cut from a glass, wouldn't there be like cuts like in the, it wouldn't be like tooth marks. And then, as she so eloquently explained, when a person pulls their arm away and they have a shirt on, a long sleeve shirt like I have on here, and the dog bites down, and you're pulling away, it's going to pull your clothing. It's going to make that mark on your arm. You wrong. Drunk on drugs, you wrong. KP says, Dr. Russell probably read that book on the plane home. She won't be caught off guard again. She won't. Because she was like, what is this book? She's like, yeah. And then she's like, let me see it. That was the best. Let me see it. Let me see it. And she's like, do any of these people? She's just looking through. It's like, it doesn't even say that any of these people have degrees that wrote this book. Because, it would say, like in there, it would say in the, section where they talk about the authors, right? Wouldn't it? Probably. Maybe. Here's an anonymous viewer. You're amazing. Please don't say my last name. Okay, well, I'm not going to say your name at all, except to go like this. Thank you for all your coverage. The ducks are free on YouTube. Yes. Thank you. Tim says they're from a dog bite. That's what I'm saying. Dog attack. And no other scratch marks. Okay, says MD. Jamie says he wasn't found on concrete. And Kate says, thank you, Kate, for reeling it back in here. The glass wasn't the same glass that John was carrying out of the bar. That is right. The glass on the bumper didn't match the glass on the lawn. The glass on the lawn, did anybody even ever establish that the glass on the lawn was not from inside 34 Fairview? That's what I said. Day one, I'm looking at this case. I'm like, at the very least, I think, like the day one that I'm reading the police report with you guys all the way back in January of last year. At the very least, I think that they should have at least gone in the house to see if they had those kind of glasses in their cupboards, cabinets, bar, to see if that glass came from inside the house. At the very least. At the very least. Do we even know if the waterfall had that kind of glass? Mazza, do we even know? Hi, Mazza. Yeah, a glass cup shattering will not result in pattern wounds. Very good. Excellent. Excellent point. And you still have bruising. Where's the glass in the wounds? Why did they not even go in there to see if they had that kind of glass inside their house? Okay. I don't know. You'd have to bounce like 5 times onto the grass. Katrina Bunny. Can't get past them trying to convince us Karen Reed hit him because she was inebriated, and their case relies on a bunch of other people who were also drinking. I mean, not so much. For me, it is like that blood alcohol extrapolation nonsense should also be just completely disregarded. That should have never been allowed in. But, she could have went home and drank a bottle of vodka. Every single person. And as she's drinking, let's say, maybe she starts getting more and more ramped up and starts leaving more and more vicious voicemails about because this guy's avoiding her. If you guys didn't see that episode that Will and I did, The Glare, on his channel, we did a read through of all the text messages from that day, from January 28th, between Karen and John. There's a lot more to the story than they told them about a trial. There's a lot more to those text messages. And it wasn't like they were in a fight. It was like he was mean to her that morning and he was avoiding her all day and she wanted to fix the problem and he didn't want to fix it. And then he wanted her to come because he needed a ride home. And then he got mad because she hired a plumber instead of letting him and her dad, his dad and him fix the plumbing. Like there's a lot more to it. That was a great episode that we did. I will, if I do say so myself. But it gave a lot more insight into what their relationship was like and the dynamic between the two. And also, who knows how inebriated she was at the time, because every single person that was interviewed by Proctor and whoever took their witness statements that was at the waterfall said Karen did not appear to be drunk at all. So I have questions about that. And then they draw her blood, 8 hours later. subject to a section. It's not even drawn properly according to MSP standards. It's not even the proper testing that they do to test BAC to prosecute someone. Was she ever given a citation for drunk driving? I don't think so. There's no car accident report. For the love of the traveling Mary, there's no crash report. There's no crash report right then and there. It's like game over. You guys thought it was a car accident within 16 hours and nobody filled out a crash report. It's the law in Massachusetts. It's the law. Okay? Personal injury or death or property damage over a certain amount, you got to fill out a crash report, file it with the RMV. That's the ducking law. Okay? Don't blame me, blame the legislature. That's another reason why they're not going to be able to prove this civil case, because there was no crash report. No carrier in their right mind is going to pay on this case. They're not gonna. They're just not gonna. She wasn't given a citation for drunk driving, and there's no crash report. Two things that are completely detrimental to their case, in my opinion. Maybe they gotta focus more on that. Fuck us, we gotta fuck us. Trooper Proctor, you're aware of the rule in Massachusetts that's, I mean, you're a state trooper, right? You respond to a lot of car accidents, right? Isn't it true that when you respond to a car accident and there's personal injury or death, as in this case, you're supposed to fill out a crash report, file it with the RMV? Isn't that procedure, protocol? Maybe they need a procedure expert, because everything they did, nothing they did was according to procedure. I don't know if they allow that in Massachusetts, like a procedure expert that can talk about accident investigation by the police and like law enforcement, but maybe that would be a good expert to get. Massachusetts has all these funky laws, though. Who the hell knows? Since when do we give citations for DUI? You don't. If you get pulled over and you're drunk driving, they don't give you a citation. What do they give you? They give you nothing? They just say go home? Do they give you a ticket? You get an appearance ticket? Do you get anything? You get nothing? They just say go home. We'll come for you later. I don't know, John Doe. You got a lot of sarcastic comments in here, so I'm just wondering if you're a lawyer or like, or if you're being sarcastic. Like, it's hard to tell sometimes because there's so many trolls in here that it's like whack a troll. Yeah, you get arrested. Oh, you are you drunk on drugs? Are you drunk on drugs again? You get arrested. Uh-huh. Right. And if you're running around the scene saying, I hit him, wouldn't you get arrested? Wouldn't you get detained? If you're confessing at the scene and everybody hears it, wouldn't you get arrested? Or would they let you go home with Kerry Roberts and then call you back and then put you in an ambulance and then section you? Because I'm just curious. Kate's like, this is a red herring wrapped in a straw man kind of case. I don't even know what to call it at this point, but I'll allow it. Christopher says you get a ride to jail, then you go to court. You get an arrest. In the clouds, became a member. Thank you. Thank you for bringing me a member. Welcome. Oh, Meeple Barcy Sketty Stain says, so my unhinged voicemail made it on episode 10. Congratulations. Did you leave an unhinged voicemail for Mr. Phelps? That was you? Well done. But I mean, I forget what it said. I think you, okay, I think I do. I remember this now because I only watched this or listened to it in my car the day that it came out, which is only like Thursday, right? It's already Sunday. So I feel like I've lived a lifetime since then. And I don't recall exactly what you said, but you were kind of like, you didn't even tell the truth. You're a podcaster. You're full of it. I mean, it was amusing. Congratulations. Did you get paid for that? Did you sign a release for that? Did you sign a release allowing them to use your voicemail? Because that's interesting. I'd like to know. They use your content. Did they compensate you for it? Did they give you any sort of permission slip to sign or any sort of release or any sort of NDA? Anything? Paperwork? Was there any paperwork at all? Minor, did they disguise your voice? My name's Kel. Bev needs investigated charge removed from bench. Thank you for your opinions, Kel. And the clouds became a member. Yeah, I do. Mm-hmm. DUIs or OUIs get a citation. Thank you, Squirty Belly, David Reese. Mm-hmm. Yeah, Linda says probably depends on who the cop is. Yeah. Mm-hmm. Right. Karen Reed was initially let go from the scene and her vehicle wasn't even there at the time. That's true. This is true. And Sharon creates. Are you frantically crocheting? We have a rage crochet club here. You have to be caught driving to get an OUI, right? But they're charging her with it, right? Mm-hmm. Ipsy Dixit. Thank you. Much love and appreciate much love. But back to you for my legal expertise. Oh, thank you. Bring it in all these cases, but gotta go to bed. Good night. Good night. They never asked the bartenders how many they served her, says KPT. Nope. And where's Yuri's math teacher, Ben? Yuri's math teacher, I hope you're okay. I've been missing you. I haven't seen you in the chat lately, but Yuri's math teacher says they all of a sudden started talking about 9 drinks. There was never any actual evidence that there was 9 drinks. There was one receipt that we saw during trial that said 2 Tito's on it. Never saw any other receipts. Never saw any bartenders testify about how many actual vodkas they gave her. KPT, great point. Big old dog says, bingo. Melanie, go through all the P and show they didn't follow any of them for a fallen police officer, right? Procedures and policies and procedures. Dr. Russell taking the bar exam. She probably is over the weekend. She'd be like, I could just go take it. I don't even need to study. Right. Wouldn't someone say, we need to see your vehicle? Maybe. But that's what they seized it sight unseen, Kate. They seized it sight unseen without a warrant. They just went to Dighton and just took it. Joseph, it seems so basic, but how about securing the scene? I think my Ginger may have done her business there because no yellow tape. Yeah. Nope. LA says they need to explain the text stream data because the jurors took Trooper Paul seriously. Yeah. Yeah. But I think the information that juror gave to Phelps, excellent knowledge for the defense. So there's that. Jamie says you get a citation if it's a friendly, and they'll drive you home too. That's hilarious. Ann Smith, the traveling Mary should just be placed in front of the court when Karen's trial starts again and stare right above. Can we bring the traveling Mary? Does anybody know if there's a local traveling Mary? Because we started talking about the traveling Mary during the Maya Kowalski case, which was in Florida. And Maya Kowalski was a very sick little girl, and the church women tried to bring the traveling Mary to visit her, and the hospital JHatch would not let the traveling Mary in. So we're all about the traveling Mary for the love of the traveling Mary. And is there one? Everyone's like, that was an awesome voicemail. It was Boston Honest, says LA, best voicemail ever. I'm a little behind in the chat, as you can see. Amanda, is that Amanda? That was a fantastic voicemail. Oh, everyone's in love with your voice. See, a lot of people did listen to it. Margaret says there is an arrest report. There is an arrest report for the DUI or the UI or for the car accident. Or there's a crash report or an arrest report for the DUI. Meatball says, congrats for getting published. They were accusing everyone of being Amanda on X. Oh, see, I'm not in the cesspool. I don't even know these things. MD says, so a woman is yelling, I hit him while drunk on drugs. With a dead man lying there, they let her go after all that. Not drunk. Yeah, they let her go. Just let her go. Until Proctor had the idea to pin it on the girl. Oh, Meatball Morrissey's Sketty Stain says, no, I actually told him explicitly that he wasn't allowed to use my voicemail. Oh. Well, that's interesting. Huh. You might have to cut it out like they make you do on YouTube. If they find any like copyrighted content by the AP, they make you cut it out. Do you have a lawyer that can send him a cease and desist? Oh my gosh, Swiss Miss is hilarious and on point. It's 5-star. Says Joseph, it was 5-star. And says, I have the texts where you said you can't use it. And he used it anyway? Oh, I don't know. You might have a claim. I'm just saying you might have a claim. I'm not a Massachusetts lawyer, but you might want to talk to one. You might want to talk to one. Call Bradle. Call Bradle. Bradle's the best. You saw him in action. He's the best. Call Bradle. He's the best. Fantastic. Better call the Phelps line right away. Your info. Oh, here. Trooper Paul's pirouette says it would have been a whole different situation if she had been there in her car. That's why it was so important that Jen decided she shouldn't drive. Interesting. Squirty Belly says, a DUI results in being detained until a BAC is taken, then a criminal citation is issued. Okay. Patty's giving you 5 stars, I think, for your voicemail. Donald Duck says DUI is a citation in Massachusetts since most judges apparently go to happy hour at 4 p.m. Fantastic. You guys are fantastic. All right. Any closing arguments before we go? Closing arguments, thoughts, concerns. This was a fun way to spend an evening with you guys. As always, you keep me laughing, and sometimes we got to laugh or we're just going to cry. But it is comforting to know that the SJC is not afraid to sua sponte, amend jury instructions, and also to do such things as broaden First Amendment protections, expand First Amendment protections. So that's good. Seems like they care about your constitutional rights. The SJC does, my friends. The voicemail, I can't really. Closing argument is you wrong. You wrong, V. You wrong. No, I'm not wrong. You wrong. Somebody said can anybody summarize the voicemail? It was basically like, Phelps, you're a duck and idiot. You don't know what the duck you're talking about. You're a liar. I've listened to your podcast. Everything you've said is lies, 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 lies. Yeah. We have emojis for that. Remember the Thompson twins? Let's hear the lies, lies, lies. If anybody wants to quickly summarize that voicemail, it was basically like, you're a duck and idiot. You don't know nothing about nothing. And it was a little explicit with language. And it was a rant, I would say. Right? Anybody? Anyone? And stop accepting Ipsy Dixits as facts. All right, Ipsy Dixit is because I said so. It's because I made it up and said so. Ms. Holmes coming in with a late night 10. Melanie, here's what happened. McAlbert beat GAOK and unfortunately unalived him. VA called Proctor and gave the code word, and he took over. Quote, death process began, and Proctor told LEOs to fall in, and they were off. Ms. Holmes, if you were to script that in Hollywood, your editor or your writer's room might come back to you and say, this is a little far-fetched. It kind of strains credulity. We can't possibly produce this. Nobody's going to believe it. Yet, here we are. And they couldn't script it any better if they tried. Thank you, Ms. Holmes. The last minute super chat. All right, you guys. So back to the Alexander brothers tomorrow, the bros. The heinous bros, if they do that hearing live. If not, let's just take a look at the week, shall we? And also, I want to know what you guys want to talk about. We got Luigi Mangione. We got things that we have not discovered. Rex Heuermann is back in court on Tuesday. That should be interesting. I may have to go to Riverhead for that. Aiden's cases are on Tuesday afternoon, right? 2 and 3 p.m. We're going to have to cover those live. 1 in District, 1 in Superior. That's going to be interesting. And then Richard Allen's sentencing is on Friday. I've got that on my calendar for Friday. But of course, no cameras in the courtroom there. I wonder, is Andrea or anybody going to go back to Delphi for that? I wonder. Has anybody been talking about going back there for that? I don't know. But we have lots of things to talk about. Luigi Mangione. We haven't even talked about him yet since the breaking story that we did of when Brian R. Thompson actually was shot. Just story that day, but while he was on the lam, this guy with the city bike, the guy was tracking all the city bikes. We haven't really talked about that yet, so we gotta catch up on that. I haven't seen any of the drones. No, have you? I need to know what's going on with these drones. I can't really report on it because I don't know enough about it. But are we worried? Like, is this a bad thing? I don't know. I'm confused. JonBenet Ramsey? Yeah, I love JonBenet Ramsey case. I'm a Boulder girl, so. You want to talk about like what I think I watched the first episode of the documentary. I hope they solve that. I don't know why. Misty and Eddie said, I can cancel my cable. Thanks for calling. Thank you. Thank you so much. Kate wants to talk about Luigi. I'm trying to think what else. You say pass on Luigi. I don't think we have to do Luigi every day, but I think we need to talk about Luigi because I have a lot of questions for Luigi. Worth $100 million. Here's what I say. Here's what I'm saying. It's a dark humor joke. So if you know, you know. They're trying to extradite the 3 Alexander bros back to New York. They're also trying to extradite Luigi from Pennsylvania. He may be coming soon. As soon as that indictment, and when the indictment comes out, let's read the indictment together, shall we? And also, when the Alexander bros come back, they're going to be in the same lockup as Diddy. Okay. I got questions because Alexander's, Hamptons, I think maybe they were mentored by Diddy. I don't know. Just my own personal thoughts and opinion. If Luigi comes back to the same lockup and we have Luigi take care of the Alexander bros, can we just like wipe the slate clean and be like, all right, Luigi, you're good. You're good. Like, I mean, it's just a joke. Just a joke. It's not a threat under the law of the state of Massachusetts because I just meant that as a joke and I'm saying it's a joke. Okay. Okay. The Sheriff Stein, I've done shows on him, and I will say that I did, of the shows that I did, I went over the entire civil lawsuit. We read it together. And I suggest, because what's coming out now is exactly what I talked about months ago. I said, if this judge had anything to do with what was going on in his chambers, in his office, after hours, with that officer who was in charge of collecting the money for the ankle bracelets and having relations with all these women, if that judge was involved in that, that could be a really good reason for Mickey to have, unfortunately, unalived that man. And now it's all coming out that maybe that had something to do with it. So I'm just going to say I was right. When does Jay-Z get arrested? We'll see. It's a very, the Jay-Z case is from 2000. So the problem with a lot of these cases is statute of limitations. So the reason they were able to get Diddy is because of trafficking charges. So when they bring the federal charges, trafficking has a much longer statute of limitations. It's a whole thing. The reason you're seeing a lot of these civil suits drop right now is because for the first time in history, New York is actually plaintiff friendly when it comes to pedophiles. Because when I was handling those church cases, they were all time barred. It was like, yeah, too late. Sorry, time's up. New York has since opened up the statute of limitations. I think the final one is going to end now in March of 2025. So people are allowed to bring all these old cases now. That's why you're seeing a lot of them getting filed right now in New York specifically. So I don't know. So there's that. Jay-Z has only been brought in civilly right now. Let's go down the rabbit hole, says Kate. Mark saw the drones. He said they were weird. Oh, thank you, Romy. Rather than Luigi's new attorney, Karen Agnifilo, is Diddy's attorney's wife. Yes, that is true. Follow Karen, and I think she's fantastic, but the connection is interesting. Interesting, but not shocking, right? I mean, first of all, what's shocking to me is that 2 lawyers could be married to each other. That, to me, in and of itself, is the most shocking part of that statement, is that there are 2 defense attorneys who are married. Well, you know what? Bob and Ali Mata, they're married. And they're both defense attorneys, so I could see that. But also, there's only so many really excellent criminal defense attorneys in New York, right? So if you got $100 million, and like both of them do, Luigi's family is apparently worth $100 million. Diddy's is, and I think that's interesting, but not shocking to me at all. So, if you can afford a good lawyer, that's what you get. That's why Karen Reed has an excellent team. Thanks to so many of you generous people. All right. In the comments, be respectful. And also, please put in there what you want to talk about next. Maybe I'll have to do a poll or something because there's just so much stuff out there to cover that we can't cover it all. But we can cover what you want to cover, and I'm here for it. So I'm here for you. So you let me know what you want to do. But here's breaking news from News Nation from 3 minutes ago. Luigi Mangione supporters raise over $110,000 for his legal defense fund, apparently. So there's that. People are touting this guy as a hero. I have questions. I don't know. They're trying to freeze their assets. There's some forfeiture things going on with the Andersons. I don't know if they've frozen them yet. But that is it. All right, my friends. Thank you, moderators. This was an amazing show tonight. You did an amazing job. I know it's not always easy when we do this whole thing, with this topic. So there's that. And murder is not the answer. No, it's not. Don't do it. Please smash the like button on your way out, even if you're hate watching. If you're hate watching, just smash the down thumb button because, engagement, right? That's why so many people are ratioed on Twitter and don't care because engagement. Cupcakes, love you. You guys are awesome. And I'll see you tomorrow. Just don't know what time yet. So make sure you have the notification bell set for everything so that you get notified. Because oftentimes I just go live because I feel like it. Just happens, you know? And you want to be notified because you don't want to miss a thing. You don't want to miss a damn thing. Good night, my friends. Congratulations to Travis Hunter, winner of the 2024 Heisman Trophy. That was an amazing night in New York last night. The entire team was here. Deion Sanders was here. His mom gave an amazing speech. If you see her Instagram, go to her comments. Tell her to come on the show. I would love to hear from her and what are her secrets of raising children and how to be justices for all is her Instagram account. Okay. That's your assignment. Talk to you guys tomorrow. Stay cool, stay kind, stay classy. It is really, really, really not hard. And also make way for ducklings, my friends. Make way for ducklings. We are outraged. Peace. Have a great night.